Then the opening prayer, that was supposed to be at 2:05, so we are behind the schedule. Then we shall have the first session, will be a keynote address on enhancing electoral justice in Uganda by Dr. Kabumba. And we shall, I think, politely ask the other panelists to wait for their turn. When they are called, then they will partake their seats at the front desks. Then, after that keynote address, there will also be a speech by Dr. Ekwaru Obuku on agenda setting and policy change, strong leaders for a stronger public. There will be a plenary, and then there will be panel discussions on electoral justice in the run-up to the 2026 general elections. That panel has been amended. I will not moderate it, but I will now present a paper because most panelists did not turn up. So we shall have our brother Edina Nguru from the east, the Eastern Mountains. We shall have Mr. Justin Semuyaba. We shall have Professor Mbazira. And we shall request Mr. Okero Riem to be part of that panel for general discussions. Then there will be a plenary with questions and answers, and then a panel on civil and human rights in the run-up to the 2026 general elections, which will be comprised of Miss Hope Bagota from the UHRC, Mr. Godiba Tumushabe, CCG, then TBC, Director Legal and Human Rights. We were supposed to have somebody from the IGP or Uganda Police, Mr. Kugonza Amot from the Electoral Commission, and the others as listed. Then there will be brief end speeches by the moderator, the Vice President, and the Treasurer, and the Executive Council. Mr. Nangulu, I am waiting for the green flag so that we take off at lightning speed. In our village, we call it Iri Iri. Speed ya Iri Iri.
Thank you so much. You are most welcome to this ULS event. People at the back, you're extremely far. I can't even see you despite my enabled sight by, I wear specs that enable me to see very, very far, but I can't see you guys. We are starting shortly. So I would kindly request that come closer. We intended to engage, and this is a critical discussion. It's a critical time. Any lawyer of any name would want to know as much as they can about the election season. We have a distinguished panel of speakers who are going to break down each and every part of the electoral processes. So you'd want to learn. I was hoping would allow those who are out join us, but I think I will not take much more time. We have already had the program read. You have heard the names of the distinguished speakers. Mr. Kamba invited the speakers to the podium early. but it is good if you display the film stars before the movie starts, so that those who have come to enjoy the show can know who the stars exactly are. When they would display the flyers and the posters, people would want to know. I was asked to remind you that, remind people, some of our colleagues have already settled in for the cocktail. The cocktail is happening later. So if you have their numbers, please let them know that that we are starting. We are starting fast with this event. We can't do the cocktail. We would not be able to benefit from this engagement. Allow me, we have a number of distinguished members of the bar who are present. Each of us in your own capacity is distinguished. I would want to thank you for making time, for coming out. We are here for the longer part of this evening until we benefit as much as we can. I am just trying to buy some time for people who are not yet in to get in. Mr. Ekware Book has joined us. Thank you so much. I saw around in the hall Senior Counsel Dusman Kabega. I saw Professor Mbazira. I saw the governor of ULS. Mr. Isiko, you've sat at the back. I wish you would come to the front. We are allowed to be here. The president said that this event is not injuncted. It is not indeed injuncted. So, without further ado, I would... Hey, Brother Kanai, you're most welcome. Thank you for joining us. Without further ado, I would want us to pick up with the first item on the agenda. An opening prayer. Let me invite a volunteer who can give us a prayer. So that we can have the most fruitful engagement today. Anyone that has blessed words to, please come. Most for the lady, put her hand up first. There's something about ladies and prayer. They are always nearer to God than the gentlemen. So let us humble. It's allowed.
Good evening, everyone. Let's humble ourselves for our prayer. Father in heaven, we thank you for this day. We thank you for the gift of life. We thank you for the journey mercies that you have granted us from different places of destination. We pray that as we are in this place, may you come in as we discuss different things in the different aspects, Lord King of Glory. We pray that let it be yielded in each and every way, Father King of Glory. We pray all this through Jesus Christ our Son. Amen.
Amen. A hand clap for her. Thank you so much for the prayer. Let us rise and just from where you are, just stand up and we can go through the national anthems and the anthems. DJ, give us the anthems, please.
Mungu twaomba ulilinde Jumuiya Afrika Mashariki, tuwezeshe kuishi kwa amani, tutimize na malengo yetu. Jumuiya yetu sote tulilinde, tuajibike, tuimarike. Umoja wetu ni nguzo yetu, idumu jumuiya yetu.
Okay, thank you. Thank you, DJ. We can resume our seats. Please, if you can, just send a WhatsApp message on those many groups and tell whoever is not here that we have commenced business. We are conducting it. Okay. We are conducting everything peacefully. So that everybody is in the hall. I want us to have everybody in the hall by the time our keynote speaker takes the stand. There are so many dignified faces at the front here. People who are at the back, you need to come to the front and engage with some of these persons here. Our first item, our second item is the remarks from our Vice President. Mr. Simwe, please join me at the front here. You have chosen to sit at the technical area, yet we know that you don't have technical skills. We may ask you to make the sound better and you look back at us. You guys, it is the in thing now to carry this kind of gadget. You look at the VP's gadget that he's carrying. Please a hand clap for Mr. Simwe as he has chosen to go to the opposite side of where I'm standing. But you will hear from his remarks the build-up of what has brought us to this day and to this event. I want to hand over to you, Mr. Simwe. The mic is yours, please.
Thank you very much, Mr. Nangulu. But before we proceed, can we please observe a moment of silence for a fallen distinguished figure, Raila Odinga, from across. We are East Africans, and it's important that we observe this moment of silence. I don't know how Eddie skipped that, but it's very important. So at least about a few seconds. His soul rest in peace. Right, colleagues, first of all, I greet you. I bring you greetings from the President, who is not here with us today for obvious reasons, which you all know. And also on behalf of the Governing Council, the members of Council are around, but moving around to ensure that you people are comfortable and the day goes on smoothly. My remarks will not be the ordinary, normal remarks. At least I've started by welcoming all of you and appreciating you for coming here. But they will be strictly focused on our position, the current situation we are in, because I'm sure you're aware that under normal circumstances, every member of the bar would be here right now as the norm and would be, winding up and enjoying the evening as we setting for the weekend and prepare for an AGM, which was supposed to be tomorrow, the 18th. Unfortunately, that's not the position, but we felt as we should make sure that the normal business continuity does not get disrupted, as we've always tried to focus on that. Hence, today's event, which we all know is a pre-AGM conference, and Mr. Hassan Kamba has been clear in explaining how it is more of a sale event, as you saw the communication, because it's on the calendar. We also intentional as regards the current status, what is happening right now in the country. You all know we are in this election cycle. We all know what happens during, before, and after. As members of the bar, we have a big role to play, and we felt it's important to make ourselves ready, to be ready for, the period and execute our mandate as per of the Act, as expected. And I'll now go straight to our official statement regarding the current state, which is dated today, 17th October. And I'll give it a title that, make no mistake, Semakade's fight for a clean judiciary is our collective struggle, all of us as the membership. Yesterday, the Uganda Law Society received 2 rulings that starkly expose the rot within our judiciary and highlight the odious path to its redemption. We had 2 miscellaneous applications. There's 8/30 of 2025, Navijewa Martha and Tony Tumukunde, where the High Court yesterday issued a ruling injecting a general meeting that was supposed to have tomorrow, the 18th. And the judge did this while citing the disputed Judge Musa Sekana's ruling of 14th February, as he then was. That was in Miscellaneous Code number 263 of 2024, Hashim Mugisha versus ULS, and Edin Anguru ULS from implementing resolutions passed on 17 September. For those of you who are with us at Imperial Royal Hotel, where members attended in huge numbers and passed resolutions directing where ULS should go, or giving us direction on what to do. And this is pending the determination of Miscellaneous Code number 267 of 2025, in essence paralyzing the society's operations, including stopping the election of its Judicial Service Commission nominees for the 3rd time in 44 days, for those of you who have been following. These 2 advocates, Tumukunde and Navijewa, are the recalcitrant couple behind the suspicious, and if you remember the notice of ULS resolution published in the New Vision on the 17th of September 2025, falsely claiming to have convened a general meeting of the society at Hotel International Mienga on the 15th of September 2025. Definitely this court's decision clears 2 advocates who shamelessly defrauded the society, depriving over 7,000 members of their rightful duties under the Constitution and the law. These 2 rulings, the second court decision makes clear that President Semakade surrendered initially. If he had surrendered, as you noticed in the second ruling that came out yesterday, he would have served half of a contested sentence as of now, the 2-year sentence, only to face additional punishment after being left to wait fruitlessly for the stay, because the ruling was on the stay or suspension of a sentence pending his appeal. This is not something we should take so lightly. It mirrors the judiciary's tactics in the cases of Ivan Sebaduka and Hassan Malema Birizi, who are also unconstitutionally convicted of contempt of court and handed illegal sentences of 36 months and 18 months, respectively. These people fully served their sentence, completed, and went home before their appeals could be heard. These two rulings I've mentioned, the yesterday rulings, are, however, unnecessarily alarming. If the Deputy Chief Justice had not abruptly, because listed our appeals, as you recall, he removed Civil Appeal number 98 of 2025. That was ULS versus Mugisha Hashim Mugisha, and Civil Appeal number 102 of 2025, Isaac Semakade versus Hashim Mugisha Hashim Mugisha, from the Court of Appeal cause list. That was on the 10th day of July 2025. The disputed second ruling of 14th February 2025, designed to stifle the ULS, might probably have been overturned by now. All those rulings that were delivered that day. Because as you notice, even as the judge was giving his decision yesterday, he was referring to those rulings, which are subject of an appeal. Of course, we know these rulings are designed to stifle the ULS. And they might have been overturned, like I said, but the current endless injunctions against the ULS are a reflection of really what the judiciary is doing. The vastly different handling of these two routine court applications clearly shows that fighting for a clean judiciary is a messy undertaking. The radical new bar is obviously facing retaliation from those who benefit from the status quo. We have, and I'll not shy from saying this, we have corrupt judges who are mad in partisan politics, and scrupulous lawyers and politicians, and rapacious business tycoons who exploit a compromised judiciary, which should be better than it is for sure. The president's exile, as you're all aware, is a testament to the length to which these forces will go to silence dissent. I usually refer to him as a martyr, because his fight, his relentless fight, has led him to where he is. Yesterday's rulings as well are also a direct assault on our unity and autonomy as members of the bar. As the National Bar Association, we feel this is a cowardly attempt to usurp the authority of a self-governing institution of over 7,000 members through judicial and executive overreach. However, as the societies, we stand firm and refuse to be intimidated by these actions, by these approaches. Our actions have clearly had an impact, and we are definitely flattered that they have gone unnoticed. The reason all this is happening is because our actions have been noticed, and that flatters us as the leaders. In instigating factional battles, our enemies are aware that a disunited bar will not bear the weight of public expectations, which are both desperate and unrealistic. Fail to deliver swift change, and you risk being branded a sellout. Push, and you risk being labeled an extremist. To lead the ULS in this particular moment is therefore to embrace the messiness of the fight, to wield an apologetic truth as your weapon, to rally the disunited, to inspire the distrustful, and to persevere against the odds. And I say against all odds. In the face of a backlash, the apathy, our colleagues, is the apathy is a heavier burden than the hostility of our enemies, who are there parroting the disputed orders as though they were settled law, and feigning ignorance of our delisted appeals. They act like these appeals do not, matter at all. Of course, the decorum obsessed will dismiss this fight as impossible, as we've heard along the streets somewhere. They will instead cancel, caution, compromise, and civility. But caution has not cleansed our courts. Compromise has not restored public trust. Civility has not dismantled corruption. A radical new bar vision is the only remedy that can cut through the deep-seated rot that has long plagued our judiciary. As doctrine-obsessed fighters must be prepared to confront weaponized court processes, marred in delays and incompetencies. This fight is not a polite debate to be waged in air-conditioned chambers by the decorum-obsessed elites. It's time for us to do more than that. It is a messy, bruising struggle that demands vision, grit, and unflinching willingness to confront the decay and decadence that have corroded our courts, as most of you have been crying for. Yet within our legal fraternity are those who clutch their pearls over raised voices or unorthodox tactics, content to propose incremental reforms and indulge in empty rhetoric. All this being done while the judiciary's soul is stripped bare. These decorum-obsessed gatekeepers are unfit to lead the struggle for a clean judiciary. Their obsession with propriety over principle, with form over substance, renders them impotent against the entrenched interests that thrive on judicial decay. To lead this fight, therefore, you must reject the temptation to play by their rules. And I stress the word must. For those rules were designed to preserve the very system we must dismantle. So playing by these rules will only fail us and do not achieve the main goal. This is our way forward. One is defending the independence and integrity of the ULS is a collective responsibility of all legal professionals. Lawyers must be free to perform their professional duties and exercise their Article 29 constitutional rights without fear of prosecution, administrative reprisal, economic sanctions, or other forms of intimidation, harassment, or interference. Secondly, it's time for all lawyers of conscience to take a united stand against judicial overreach, abuse of power, and the weaponization of justice. Let us therefore start by demanding the immediate restoration of our appeals to the Court of Appeals cause list, because as you're all aware, they were erroneously decause listed, and it was clearly communicated that was the intention, and we are facing the consequences of that as of now. This would potentially terminate over 20 ongoing High Court cases and remove the looming threat of criminal prosecution against R&B officials based on SECANA's 14th February 2025 rulings, not to mention setting aside the president's illegal sentence. Colleagues, despite our differences in opinion or otherwise, which is natural, which is obvious, we must collectively decry the selective deprivation of due process, which is glaringly evident in the abrupt removal of critical appeals from the Court of Appeals cause list on the 10th of July 2025, unfairly disadvantaging the radical new bar and undermining the rule of law. This stands in stark contrast to the swift justice afforded to those who file numerous cases against the ULS, seemingly with the judiciary's full support. Secondly, we must, and I say we must, be prepared to stage a historic boycott against the recruitment of the Chief Justice, Owiny-Dollo's successor. We feel the intentional denial of ULS's participation in this process is unconstitutional and illegal. This is being done in utter disregard of our constitutional petition number 12 of 2025 and constitutional application number 11 of 2025, wherein the ULS challenges the operationalization of an improperly composed Judicial Service Commission because the ULS nominees are absent, and potentially unconstitutional regulations gazetted on the 21st of January 2025. As members of the bar, we should no longer tolerate creeping erosion of the rule of law through delayed hearings and disposal of critical petitions or appeals that empowers the power to act with impunity. Thirdly, having reviewed the injunction in the first case, we have determined that the Society's CLE calendar event slated for today, which we are having, proceeds safely. However, we feel the trial judge acted erroneously by prejudging the main case, purporting to alter the status quo and disregarding the clean hands doctrine, among others. This is the main application coming up on the 20th of this month. I think that would be Monday. We therefore, as council, intend to move forward in the following ways. One, seeking the trial judge's recusal, applying to set aside or modify the injunction, and pursuing an appeal with a request for a stay of the status quo. As I speak now, I believe these applications must have been filed by our counsel to the bar, Mr. Jude Byamukama. Fourthly, the President's legal team will seek substantive and provisional redress from the Court of Appeal, having filed civil appeal number 1012-2025 on 18 February 2025 to challenge the abuse of judicial power, specifically via the outdated offense of scandalizing the court, which you also saw being emphasized in yesterday's ruling. And finally, we call upon all the members of the bar, not just R&B supporters within and beyond ULS, to join us as in this process of confronting the systematic corruption and the entrenched inertia with the legal fraternity that prefers the comfort of complicity to the discomfort of change. To our colleagues who are content to profit from the status quo, representing clients or causes in a broken system without questioning its foundations, we say it is time to take a stand. This is our profession, and it is our duty to protect it. So members, we've been asked questions since yesterday on our position as the governing council and as far as the outcome of yesterday's rulings is concerned. And what I've just shared is the position of the governing council. It's signed by all the council members, and we'll share a soft copy of the same. I felt it is important to put it across so that the members in the room understand the state of things and what our position is. As you're also aware, we chose to respect the court ruling of yesterday, much as we dispute it, and that is why we shall not be holding the annual general meeting tomorrow or conducting the elections for the Judicial Service Commission representatives. That notwithstanding, we are taking steps to ensure that we get all this out of the way. We take matters into our hands as the members of the legal profession. This is a National Bar Association which should be respected. Our autonomy must be respected. And we are not going to give, no one is going to give us this. We have to fight for it. We have to grab it from the fists that hold it. Because as it stands now, that is what is at stake. Our independence, our autonomy is at stake. And it is your duty, each and every one of us. It is not the role of only, the council members or the leaders, but each and everyone's duty to fight for what is rightfully yours. And that is a clarion call we are making as members, as your leaders. So members, as I sit down, I do wish you good deliberations. This specific CL event, this specific conference was designed to benefit the members of the bar, as I said earlier. The current state of events, we all know that most of us will be very busy after January, receiving instructions. Others will be busy during this period, also receiving instructions. And we felt it's important to refresh our minds and appreciate the best practices and also hear from the best. That's why I'm much personally anticipating to hear from our keynote speaker, because I've now come to learn within these few months that I've been in charge of the R&B. It's very hard to separate politics from leadership. and you cannot run off from that fact. So as we prepare and gear up for the coming events, let us try to make the best of today. Of course, we are winding up with a cocktail, which is ready. I'm told some members are already down there. I hope, Eddie, you've called them here. You inform them that are going after this, because I'm meant to understand others have started with a cocktail. Yet it should be an event that happens after. Tell them not to worry. We are here till tomorrow probably. And let them be patient. We first get this out of the way. But members, as I conclude, and as we, have these discussions, these intellectual discussions on handling of election petitions, representing clients in those matters, we must clean the courts where we are going, because if we do not have competent and clean courts, and as you're seated with them in court, they're just laughing at you because they already know the outcome. In fact, some of them will begin appearing with a bill of costs, which is already drafted. But then whose role is it? Two of us go there to seek justice, not just for our clients, but it is a business place for us as members. So we must ensure that we clean the judiciary. We put it where we want it to be for the benefit of our profession and our practice. I thank you very much, and I wish you the very best of the evening.
Thank you, Vice President. We want to appreciate you for the detailed speech you have given. As you were speaking, I heard mamas. People were saying that we should leave the book of Lamentations and go to the book of Acts. Because when you castigate those who want decorum and formalism, maybe the governing council should one time think of taking appropriate steps other than lamenting every day. They hit us here, they hit. Thank you very much. I want straight away, we apologize first of all for starting late, but it was necessary that the Vice President gives us such beautiful keynote. I remind you that this is a CROE training. Don't record us and make us parties to suits, please. We kindly beg. And mostly when you sit behind there, our fears is over. These are the ones who are opposite to the thing. Kindly move in front, members. I want to take this opportunity to invite Dr. Businje Kabumba to present his keynote address. Dr. Businje Kabumba is a doctor of the Human Rights and Peace Center, doctor of law at the URIPEC of the Makerere University. He's also a senior lecturer of constitutional law, mistaken, where he has taught not only constitutional law, but also public law for close to 2 decades. In 2016, he was recognized by the Supreme Court of Uganda as being widely researched, I think together with Dr. Ambazira, who were amicus, that he is widely researched and highly experienced with regard to constitutionalism, human rights, and good governance, and on that basis admitted as one of the amici curiae, friend of court, in the presidential election petition of Amama Mbabazi versus Yoweri Kaguta Museveni Tibuhaburwa and another. Constitutional petition number 1, Supreme Court election petition number 1 of 2016. He has also been engaged in groundbreaking public interest litigation before the courts. He is broadly active in the areas of constitutional law and history, comparative constitutional law, and public law generally. And I want to say that he was also assigned the duty to make by the task force on making of the election manual. You know it better, maybe you will. So kindly, the microphone is yours.
Thank you very much, Bwana MC. And thank you to the ULS for the invitation. 2 days ago, I was invited to come and give this keynote address, and I resisted for some time. I didn't want to speak. There's that clip by Jose Mourinho where it says, how does it go? If I speak, I'm in big trouble. I don't want to speak. I didn't want to speak for many reasons. Partly because there are very many people here in this room who can speak to this issue far better than I can. And so the question becomes really, why shouldn't our seniors really make this address? That's one reason. The other is more of a question as to, I think the MC touched on it, and also in the president's statement read by the vice president, the question as to then, we have indeed spoken quite a lot in air-conditioned rooms. So there now indeed seems to be now a question as to, okay, what next? The speeches have been speeched. That was another reason. So Uganda is that country where even when you're young like me, you feel old. Which is strange, because when you teach first-year students and you talk about the Kayunga riots of 2009, they cannot relate because they were born around that time. Now those are the new lawyers coming up. So even at my relatively young, you feel old internally because the speeches have been speeched. So there's really an urgent question there for us to what next. Incidentally, I saw our friend Munabi Philip entering. Yes, good afternoon, sir. I voted for you, incidentally, because I wasn't sure about Salibabu. See, wait, yo. So we're not having a pre-AGM. This is not the pre-AGM, isn't it? It is what, Mpozi? It is a CLE training. We're not having a pre-AGM because the AGM was injuncted. So this, for avoidance of doubt, is not a pre-AGM. We've come to learn about democratic governance and what else was on the change thing? Civic engagement. Please, for purposes of pleadings, let's be clear. Civic engagement, democratic governance, and not a pre-AGM. Come talk about electoral justice for purposes of the continuous legal education as per the calendar that was preset. So the affidavits should be very clear on that point. Whoever is taking notes, let's be very clear. Of course, there's a very big elephant in the room. And that elephant, therefore, is really about the things we can say, the things we cannot say, the meetings we can have, the meetings we cannot have. And I'm glad to see Dr. Edward Obuku here. And I wonder what is running through his mind. Because lawyers are supposed to be very powerful people. in any society. That's the reason why, while Makerere University was started in 1922, no law school was started there. For the entire period of the colonial rule, no law school, legal education was denied, but medical education was started. So the College of Health Sciences and Medicine began, but it wasn't until 1962, after independence, that Africans could study law. Why? Because our profession, whether we like it or not, is subversive. Our profession, whether we like it or not, is powerful. And that's why our colleague Munyagwa, there's that clip where he's saying, I'm not an ordinary person, my friend. I'm a lawyer. Ours is a profession that whether we like it or not, we engage with power, we resist it, we constitute it, we wield it, whether we like it or not. There's an entire third branch of government that is composed only of one profession. And that's a very powerful thing. Of the three, a third of government, 1/3, made up of lawyers. And for a long time, there's a heavy representation in parliament also. And even in cabinet, there's a heavy representation. So whether we like it or not, whether we seek it or not, the Uganda Law Society and the lawyers within it wield substantial power. And as to what we do with that power, that's another question. But the power is there. So we should therefore not be surprised, I think, that this storm is ongoing. It's a necessary one. In fact, in many ways, it's a healthy one. And that's why some of us who had retreated from the affairs of Law Society are back, because for the first time we see a Law Society engaging with the important issues of the day. An acknowledgement that we do politics every single day. Professor Lokonyango wrote the book, When Courts Do Politics, but lawyers also honest every single day. Our work is political in a very deep and meaningful sense. That's why being powerful, I'm sure, again, Dr. Book is asking, but these powerful people now cannot meet. They have to change the name of their meetings. The lawyers are scared. They have changed the program to read from pre-AGM to, you are scared. The radical new bar is not too radical. The radical new bar is a bit scared. And I think that is the concern Kamba was perhaps saying, that Mbu, others are saying, you are saying it, Kamba. You say it with your chest. Maybe that is part of the concern. Maybe Malema Breeze has shown us the way forward. And incidentally, and this for me caused me great sadness, the time our friend and colleague Aaron Kiza was arrested, in the course of his duty as a lawyer, one of our colleagues, now that word at some point loses meaning, because I think from a secular sense, I'm now using the example from a secular sense because some of us are from different religions, but just taking the Bible as a document of information. There's a story there in which Jesus is teaching and they said, Master, your brothers are here to see you. And he asked, but who are my brothers? And his answer was, those who are in communion ideologically with me. So again, the word colleague is something we must use very sparingly. Now, one of our colleagues was on TV that morning saying, by now, Aaron is in prison and they have cut off his hair. That seemed to be a celebration of the humiliation of a lawyer. And I found it extremely sad. But it's there, it's recorded. What kind of lawyer takes pride in the humiliation of it? Regardless of your differences, or whether you're in the radical new bar or in opposition, regardless of any differences, the idea that even if the person was not a lawyer, say a Ugandan, say a human being is incarceration, you're taking pride in the fact that by now the hair has been cut off. Of all the things, you're happy, gleeful. So maybe Malema Birizi has shown us the way by entering there and demystifying the prison. Maybe Aaron Kiza has also shown us the way by entering there, and also in a sense, although for Aaron it may not have been quite voluntary, it was a bit quick. It was a bit too quick. And also, admittedly, Malema Birizi also perhaps did not go voluntarily, it must be said. But nonetheless, you know, there were the stories of exile. There was a time when those stories were stories we heard from our parents. In those days of Amin, you know, things were bad. Somewhere in Zambia, a lot of the cabinet, incidentally, and the judiciary and members of parliament, they tell stories of their various exiled, somewhere in Zambia, somewhere in Kenya, somewhere in Tanzania, Sweden. The stories of exile were stories of those days. But now, exile is happening. People we know. Stella Nyanzi, Nicolas Opio tested it, Kakwenza. And when that happens, both exile and prison, when those who enter prison are people you know, lawyers, friends, colleagues, logically, it means that that state is not far from any of us. It means that however safe you think you are, I don't think Aaron Kiza woke up that day, had breakfast, planning to not to come back. No, his car was outside. He fully planned to go back home. Only in the course of the day to somehow have his residence transferred. When that happens, we have to prepare to be each other's sureties. He's out on bail, as we know. He hasn't told me where he is at the moment, but I pledge to the court to know where he's going to be at all times. But we then need to know that it can happen to any of us. Needless to say, the president of the Uganda Law Society, the president of the Uganda Law Society is not here today, has not been here for a number of weeks. It's not cultism to mention it. It's not that I've not spoken to him in a whole number of, because he's fighting his battle. It's not about being in a cult of Semakadaism. No, it's something more important than that. It's the idea that we should not be complicit in normalizing the abnormal. And it's something very simple to do. Hannah Arendt, the German philosopher, wrote a book called The Banality of Evil. And it suggested that, again, when we hear the days of Idi Amin, we think that, when you see the movies, they're in black and white. We assume that the world, when you saw outside, it was black and white. In our minds, we think that when you see outside, maybe Lake Victoria was not blue. It was like this. There were days like this, ordinary days. It wasn't people being massacred on a daily basis. Hannah Arendt's suggestion is evil happens not as one wonderful, shocking act on one single day, but small things, small compliances and actions and inactions. Those who sign the warrant, the committal forms, they are not bad people. The judges who are part of the process, the legal clerks, they're not bad people. The prison warders are not bad people. The person who drives the prison car, taking the person, they're not bad, evil people. They are living their lives. They are doing their jobs. But collectively, by their inaction in the face of the larger evil, they become complicit in it. That's how millions of Jews were killed, while Germans went about their daily lives. That's how people in Uganda were killed from 71 to 79, while the world continued. Evil is banal. The sun shines, rain falls, people have meetings. That doesn't take away the abnormality of the situation. So part of the task that we have today is to recognize the abnormality of the situation for what it is, because that's the first step to confronting it. And that's why, with respect, I cannot, in good conscience, talk about enhancing electoral justice in Uganda. Because what electoral justice is there to enhance in Uganda? What justice is there in Uganda, whether electoral, criminal, commercial, land, civil? What justice is there in Uganda? As the Vice President has said, the Vice President is a polite man. I also didn't vote for him. But I'm sorry now. Anthony, I'm sorry. I should have voted for you. I didn't know either of the candidates. I thought it was important to have a woman also in the executive, so I voted for her. I don't know how she would have turned out if she had, I don't know, but honestly, Anthony, let me take the opportunity to apologize. You have led well. So our very polite, and the word is what, perpendicular? Our most perpendicular Vice President has said very politely that, there might come a time when you go to court with lawyers who have the judge. He was being polite because we know it has already happened. That lawyers go to court and then immediately start warning you of what is going to happen the next day. They tell you to prepare for the ruling. With such confidence that it can only be because they have had notice of the ruling if they have not participated in the drafting thereof. Let's be honest. There's a certain confidence that can only come from the fact that you have had sight of the document of which you speak. Otherwise, you would have been more reticent. You would have said, hey, people, I don't know. What happened in court today? I don't know. Let's wait. But to have someone celebrating ahead of time, so the justice, there's no justice to enhance. Mathematically, 0 times 1 million is 0. I know when we say Christ in the judiciary, it sounds hyperbolic, but it has been a creeping problem. We had Sewaduka called the Supreme Court a council of fools. Of course, those words are not very polite. They're bad words. But he got how many years? Were they 3? 3 years for saying the Supreme Court is a council of fools. Of course, the Supreme Court may not be, really. But who of us has not been abused? Every single day, we are abused. But if everyone who abused us went to prison for 3 years, of course, Malema has also said bad words. The words were not good. Let's agree. The words were not very good. They lacked the kawo. We also have to agree that the words our president said were also bad words. Let's agree. Let's be honest. The words were not sweet. They were bad words. But to be in a Uganda where bad words lead to imprisonment, that's not a democracy. That's not justice. There are other remedies. In tort, slander, libel, defamation. So many civil remedies. Part of the problem is in the constitution itself, of course, because Article 28 clause 12 says, except for contempt of court, which seems to make it a special exception. But even then, there's a discussion being held as to whether or not questions of due process also must not apply there. Part of the problem is in the constitution itself, but that doesn't justify the further abuse of that power. So certainly, in this not pre-AGM, I think we really should take some time, if not most of the time, discuss the crisis that is already with us. The crisis that is already with us in terms of the judiciary, in terms of the practice of law, in terms of the very idea of law itself, in terms of the fact that we have a president who reviews Supreme Court judgment decisions. He reviews them. As soon as the Supreme Court has rendered this judgment, as in Kawaziguka, he then renders the supreme decision. He tells us which aspects he agrees with, which aspects he doesn't agree with, and then proceeds. He proceeds then to set aside, effectively, the decision. Quickly, it happens very quickly. Public participation, Article 38, dead. Consultation, dead. We have achieved the things he talked about a long time ago, a parliament that is dead, that rises up to say aye. So we're already there. We're already in a place where, yes, you take instructions from the client to go and do what there exactly at the court. What is there, colleagues? What is there at the courts? Who are there inside? Yes, the buildings are now, there are very many. The judges and magistrates are very many. Quantitatively, the numbers are there. Numbers. But qualitatively, who are in those buildings? And what is the quality of justice in the decisions and rulings that come out? Even grammatically, many of them, even just in terms of grammar, but that's the beginning. That already is a sign that what's going to come is bad. But even substantively, you read a decision, a ruling, and you wonder. There's an old book written by a colonial anthropologist, Fallas, called Law Without Precedent. He was writing about the customs of the Basoga in eastern Uganda. He was describing it as a situation of law without precedent. That you have decisions, and the ruling is made immediately, but there's no reference to the prior decisions of the courts. And indeed, that it's the case in many of our cultures and customs. There's a reference to a general idea in some cases, but traditionally, you didn't have justice. You didn't have the decision makers citing, as we decided 5 weeks ago. No. There'll be a broad reference to cultural practice, etc. Dr. Benson Tusasirwe, in his thesis, cites a case before the Ankole court, again, that basically the litigants come, they quarrel for about an hour, it's very loud, then suddenly there's a decision, people go away. So law without precedent was not just in Busoga, I think it was all the Kingsmen by Dombos, what you were citing. That was our pre-1894 approach. Colleagues, it seems we are back to that. We are back in an era of law without precedent. It's not just in the magistrates' courts, it's in the High Court. And certainly it's in the Court of Appeal / Constitutional Court. A decision comes out on Monday saying one thing. On Wednesday, another one comes out saying completely. So what is the law? And it's not just in constitutional law, which I'm intimately aware of. It's in other branches of law. About 6-7 years ago, there was a training happening in Arusha organized by the Center for Strategic Litigation. They wanted someone to close the proceedings. They had asked me to reach out to a justice of the court. I called Justice Kenneth Kakuru. I think it was either pre or post-COVID, I don't know. But I remember that conversation because he said, I cannot make it. I'm not feeling very well. Of course, in the event, I quite understand. May his soul rest in peace. But he felt it important not to end the conversation there. He was evidently burdened. He said, yes, I cannot make it for that event, but there's something I want to discuss with you. Honestly, the things that are happening in the Court of Appeal. And he decried and bemoaned the idea that in the court he served, he himself could not understand what was going on in terms of the sheer inconsistencies in decisions. Not in just one area, but in all the areas you can think about. Law without precedent. We're back in the era of equity where the decision was as long as the chancellor's foot. What the judge had for breakfast that morning will determine the kind of decision. There's no principle. Incidentally, that is bad. That's a very terrible situation. It's already happening. But there's another development, which is even worse. Where you have the settled law, then you have some judges, either the High Court or Court of Appeal, taking another path without explanation, without rationale. Clearly, what is the Latin term I forget? Per incuriam. No explanation as to why the departure is. They behave as if the precedent is not there. Then create new law out of thin air. Out of thin air. In such areas as habeas corpus. Such a fundamental right that is under Article 44 is non-violable. In such a critical area. Bail. Create new law. Without shame. Then they sign at the bottom. Judge. And add a seal of the court. It becomes a decision of the High Court of Uganda. It becomes a decision of the Constitutional Court. Now, what is worse is that then you have self-reinforcing. Then they start citing each other. That's what is worse. That's what is worse. It was bad enough that one person was doing bad things in their courtroom. But when you start having a vicious cycle of self-reinforcing badness, you have a bad decision, I cite it, so then I'm creating legitimacy, then you also cite my bad decision, so you have layers upon layers of bad, per incuriam, not supportable decisions. So the law is here, they have gone this side, shamelessly, with impunity. And then what is even worse, they are the ones who are on fast track for promotion. It seems as if these days, to be promoted or even perhaps appointed, you must do something very bad. It seems that's the test for judicial office. You must prove that you're able to do something very bad. It seems that's the test. And having passed that test, then you're appointed and then promoted at a supersonic speed. But then you have islands of excellence. You have a person like Judge Mubiru serving with distinction wherever he's placed. You read a decision of the judge and you say, yes, you're happy. It's well thought out, serious. It's a serious decision. One whereby at the end of the day, when you read at the bottom and you say Judge of the High Court, you say yes. This is what would ordinarily be expected of a judge of the High Court. It used to be, when we were studying law, that was the norm. That you'd read a judgment and you'd expect to find justice. Now, unfortunately, that is the exception. And that's very sad. That is scary. That is dangerous. Now, it's even worse, of course, when it goes into the question of electoral justice. And unfortunately, it has already happened. Kamba knows this, and other practitioners in this room who practice electoral law. You will know that the decision, especially when it comes to parliamentary elections, the decision will depend on the panel. You see the names on the panel and you can guess, either depending on the political affiliation of the petitioner or respondent, you can guess dismissed or upheld. You can guess the finding below. Then the problem with that, of course, then you have to work backwards as to find the rationale. That's where you then find so many conflicting decisions that are irreconcilable. But of course, there are so many coming out in such a short time that we move along. So there are cycles. But if you get the body of jurisprudence 2021, 2006, and just look, it becomes immediately clear that there's no law there. No law to find. Then the actual conclusion is that if we're being honest, the law on parliamentary elections depends on the panel. If we're being honest, that will be the answer. And that, of course, is a very sad but also dangerous situation. I think you can see why I didn't want to speak. Because now these things I'm saying are bad, are dangerous. There are invitations I'll never get. There are rooms I'll never enter. There are conversations I'll never be invited to. And certainly judicial office is out of the question until that man, Engule, that one, over. I don't know. But that's 5, 10 years, 15, 20, I don't know. I don't know because already we've been shown the successor. We know the crown prince. And unfortunately, we even have the success of the crown prince has already been shown to us. Things in Uganda are bad. Dr. Igwaru, things are bad. The lawyers themselves we don't know what's happening. So certainly, colleagues, what our most perpendicular vice president was talking about in terms of the future is in fact the present. The judiciary is not ours. It belongs in the first place to the person under whose signature all the judges have now been appointed. All of them. High Court and above. Every single one person. That's not normal. That's abnormal. Not just appointed, but increasingly now on probation. Now even appointed on probation. Acting 2 years. Pending good behavior. So you serve at pleasure, you are tested to see if you're going to continue doing, because I think maybe in the past someone promised they're going to do bad things, then got into office, had tenure. So now you're tested for 2 years to see whether you're going to continue displaying the ability to do bad things, and if you confirm that, and then... So the manifestation of this thing that we talk about, the judiciary in crisis, is all over. In terms of the increasing abuse of contempt of court, in terms of the negation now of habeas corpus, both in terms of the judiciary, but also in terms now of those to whom the writs are served. In the past, there was embarrassment. Now they say, we don't have the person. Then what do you say? They took him, everyone saw, the number plate is there, the people are known, and the writ is returned saying, we have searched. Now, that's a very dangerous place now we are in. So he's not here. What else? The denial of bail, where the decision comes and says they acknowledge mandatory bail, but how does a but come in with respect to a mandatory command of the Constitution? Where is the but? But what? The question is clear. It's there. Yes, bail. You can apply for bail and shall be given a discretion of the court. Yes, but the Constitution itself says, is it 23 clause 6? When you in fact, technically speaking, it seems you don't even need to apply for bail in those circumstances. In a normal situation, that provision would be self-executing. That it would be the task of the minister to be proactive and find who are those who have spent the mandatory period. And those would be automatically, because the provision does not say they shall be granted bail when they apply for it. Does it mean that if you don't apply or if you're not aware of your rights, you can be there for 10 years? Is that the suggestion? yesterday, I think, was it 2 days ago, some gentleman appeared, 23 years without committal. Lost. But now someone applies, and you cite the law, you cite the Constitution, then you say, but. That means the Constitution has lost the power it proclaims for itself. Because Article 2 says, this Constitution is the supreme law. Any other law practice is void to the extent of the. But you have a judge saying, but, in respect of a mandatory thing. I've already spoken about election petitions in terms of the manifestations of the crisis. A couple of months ago, I was in court waiting to be a surety for one of the protesters. I have not mentioned the court out of respect, because the judicial officer was a young one, evidently. But what happened in that court is shocking. And I suspect it's happening in many other courts. It's a magistrate's court. As we were waiting for the accused persons to be brought before the court in one courtroom, we had commotion outside. The protesters were shouting. We thought maybe they were being, young people were being a little bit. Turns out, they had already been remanded that had lasted 2 minutes. Their lawyers on the premises, their sureties were in court. They were taken behind to another courtroom quietly. As they were entering the court, their charges were being read to them. They protested, they said, but if your lawyers were serious, they would be inside here right now. The accused person has said, my lawyer is present, the lawyers are outside. 2 minutes, remanded 3 weeks, I think. Luckily, the chief magistrate, I think, realized the gravity of the situation, had some administrative thing, and but that's happening all over Uganda. Stopping meetings of professional bodies is another manifestation of the crisis. Yes. Mutidemu. The impunity. Why have you brought me another microphone? To confirm the contempt. You're recording. Stopping and it's not new. It has happened before. Not this year, but a couple of months. It's not a new thing. The audacity of stopping lawyers from having a meeting, at which meeting the questions in contention would have been resolved by the people. Why? Contempt. 7 acting judges. Backlog I've mentioned. So many manifestations of the crisis that we have. Now, I don't want to insult the grace of the organizers who gave me 20 minutes. I think I've already done 25 or something. So in about 2 minutes, I want to close and then run away. Because I've said exactly the things I didn't want to say. This is why I don't want to speak. This is why, because I know myself. Once I say, either I don't speak or I say it as it is completely. The truth, the whole truth. And that's why I don't want to speak. That's why I didn't want to speak, Anthony, Arthur. Anyway, let's finish. 2 minutes. What's the way forward? Incidentally, part of the answer has been provided by no less a person than a justice of the Court of Appeal, Constitutional Court, at the Sam Njuba Memorial Lecture. Justice Segonda Ntende, who has been Chief Justice outside Uganda. Is it the Bible that says the prophet in his own home, his own town? One of the greatest jurists of our time, was mentored judges, and those judges, some of them who have not been fully mentored, then some of them who are not fully, then they go to the Supreme Court. Anyway, so one of the greatest jurists of our time has he described what he called the emasculation of the Constitution, and he gave its history, the fact that the 2 pillars, again, Dr. Sasiria has written persuasively and authoritative on the basic structure doctrine. The idea that the Constitution, once you remove those basic pillars, collapses. And Justice Segona Ntende described how those basic pillars, term limits, age, went away, district, cities. So in very many ways, the Constitution has lost its spirit and its guardrails. What we have, no wonder then judges say, but. No wonder. Because it now looks like an act of parliament. But then he said, that being the case, since the Constitution has been stripped of its force, and since attempts at constitutional review have now been half-hearted and have been stifled, they're no longer there. They tried to pretend at some point, they have stopped even trying to pretend. So, Justice Gonda challenged the Uganda Law Society. He said, perhaps now it's time for a civil society-led constitutional review commission. Now, of course, that sounds strange. Would it have legality? Perhaps not. Would it have legality? Perhaps not, because the Constitution talks about technically how it's amended. Would it have legitimacy? Yes. And in 2025 and going forward, I think as lawyers, we need to embrace those two ideas and distinguish clearly the difference between legality and legitimacy. In other words, not all judicial decisions that have signatures and seals, they may look like decisions. They may, in fact, enjoy the force, the opportunity to be enforced, including by police and other enforcement agencies. To that extent, they are legal. But certainly, many of them, increasingly, most of them are illegitimate. So, unfortunately, we are trained to think in terms of the law. And colleagues, I suggest that the time has now come, if not long since past, for us to think outside the law or beyond the law. It takes courage. It takes us abandoning the things that we studied. The positivism, the law is the law. The law is found in section, Article 14, is this still Article 14? Law applicable. The law written in further common law. But if the judge says, but, in respect of a constitutional command, that's illegitimate. What if the judge denies an application of habeas corpus? That's illegitimate. What if the judge stops citizens from meeting? That's illegitimate. What will you do about it? The first step is to recognize it as such and respond to it as such. And also, and this is the difficult part, be willing to suffer the consequences of confronting. Be willing to suffer the consequences of confronting and challenging that illegitimate law. Mandela was tried, the Rivonia trial, by a judge who was legal but illegitimate. And as a lawyer, he said, look, he detailed the entire illegitimacy of the proceedings of the judge, of the law, of the structure of the state. And says, look, he made his case. Says, I have lived for a South Africa in which black and white are respected. And he then said, I would like to live to see it, but if needs be, that was a very important addition. If needs be, it's an ideal for which I'm prepared to die. Now, it seems that's the point where, as lawyers now, that the radical new bar, that seems to be the limits. That seems to be the part that is disturbing us. Life, liberty, and the pursuit of happiness. Life, we like it. Liberty, we like it. We We like to pursue happiness, enjoyment. The cocktail has been promised. It was part of the organization of the pre-AGM. The cocktail glass was with pink, something pink was inside, promised enjoyments, the pursuit of happiness. But it seems we like our liberty too much, and it seems we're clinging on to our lives too much. It seems we lack the fortitude to suffer the consequences that need to be suffered by those who confront illegitimate states. Finally, the people in charge of the system that has killed the courts, killed them, they are dead. The people in charge of that system were willing to die. Some of them almost died. Museveni was in a tree, Utamaguzi could have pointed, he said he's there, survived death not once, not twice. Are we, the lawyers of 2025, armed with our good English and Latin, in the protection of the Constitution, in the protection of this profession and this ideal that we hold dear, are we willing to give up life or liberty? Maybe that's the challenge at the moment. And I'll end with this quote from 1944 by a judge called Lanet Hand, from a speech entitled The Spirit of Liberty. And I think it captures very well the dilemma we face in balancing legality and legitimacy. He says, I often wonder whether we do not rest our hopes too much upon constitutions, upon laws, and upon courts. These are false hopes, believe me. These are false hopes. Liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no courts can even do much to help it. While it lies there, it needs no constitution, no law, no court to save it. My learned friends, do you have liberty in your hearts? Do you have courage? Do we have liberty in our hearts? Do we have courage? Are we willing to pay the sacrifices necessary to protect the ideals of which we have spoken very eloquently and written radical press statements? Do we have the courage to say that indeed this was is a pre-AGM? Do we have the courage to say this is a pre-AGM? Do we have the courage to convene the AGM tomorrow? Thank you very much.
Another round for Doctor. Thank you so much, Doctor. We are indeed grateful and humbled that you spared time. He's fleeing the scene of crime immediately. Doctor, we requested that if you would share with us your presentation, it will be used in the pleadings to come. Thank you so much. I'm happy that the numbers have now increased. Doctor has said so much. I don't know where to start from, but so much has been said about justice. I want to invite the panel of discussants to break down what has been said by Doctor. This is a CLE event. It is not a pre-AGM. Those who are recording, my specific words are going to be used in our rejoinder and reply. This is a CLE event. It was not injuncted. So very quickly, let me invite the panel. I will not belabor with the formalities. We know each other. We know each of them. The first on the panel is Senior Counsel Kamba Hassan. Kamba is a seasoned practitioner of petitions. He has been a victim of injustice during the season. He has represented clients. He has also filed his own petitions. I had a matter where he was appearing in person, and he was very vehement when the judge disallowed his application for a recount. He is able to guide on some of these injustices. The next is Counsel Okello Oriem, also a diligent legal practitioner of matters involving election. He's going to give us sufficient guidance. Allow me also invite Professor Christopher Mbazira to join the panel. Senior Counsel, you are welcome as well. Forgive me for not reading. I can't read your entire bio. It is a long bio. I'm being told that there's somebody who has refused to leave the cocktail area. You people, send messages to your friends to first return to the hall. We haven't begun the cocktail yet. But the announcement is that the owner of motor vehicle UA305BS, you left your vehicle unlocked. And there's a sign in the parking that no one bears liability for whatever occurs. The last member on the panel is Counsel Justin Semoyaba, also a dignified practitioner in election matters. He's also going to be breaking down some of these matters. Allow me recognize a few notable faces. I must start with my brother, Philip Munabi. Philip, you're very popular. Please wave to the members. Please capture Philip. He has attended. Thank you for coming. There is a Senior Counsel Resida. Please also wave as well. There's James Nangwala, Senior Counsel as well. Please just wave from wherever you are, wherever you're seated. Honorable Sewonga has come to borrow lessons. He is looking to benefit from this year. Please wave to us as well, Honorable. Thank you for joining us. I think those, and the rest of you who are here as well. Mr. Ellison, the lawyer's lawyer. Please wave to us as well. Thank you for making time. If I haven't seen you, please just make sure I recognize your presence here. Now, for the panel that is before us, we have a number of areas we are going to be discussing. And I will start with the Counsel Kamba. Counsel Kamba, we have heard from Dr. Kabumba on the shortfalls in the justice system. So the question to you is, what are the pre and post election procedural pitfalls, and how should the members that intend to practice during the petitions, how should they avoid them during the petitions? Let me just repeat. What are the pre and post election procedural pitfalls, and how do we avoid those pitfalls? You're saying something? I have your notes. You can imagine. You told us that you are born and bred, that these things are within your system, but is this it? Okay, so, no, just sit. Please be comfortable where you are. This is to help you not to be recorded when the cameras are coming out. But please, the question again, if I may repeat it, what are the pre and post-election procedural pitfalls, and how can they be avoided?
Thank you very much, Madam Moderator. I'm going to be handling this topic together with Mr. Oriem. Mr. Oriem was the former head lego in the Electoral Commission, and therefore may be is better placed than me, although I've been in this field of election petitions for a very long time. And one of my worst experience was when I was in a hotel in Mbarara, and all my clothes and books and files were stolen while I was in the bedroom, including the gowns and professional attire. So I had to call the client to run very swiftly before Buked arrives. Yeah, my assignment is very simple. What are the pre- and post-election procedure pitfalls that you must guard yourself against as an election petition practitioner? We're aware that the 2020-2021 election petitions in the 2020-2021, 25% of those petitions were dismissed on technicalities. Either the commissioner wrote their names and forgot to put their title, grade 1 magistrate, chief magistrate, dismissed with the costs. First of all, I'll begin with the pre-election, the post-nomination period. It is very critical now that you pay attention that there are some matters which you must only challenge after nominations. And once elections are held, very strangely, the court has held that you cannot challenge some matters, even overturning some Supreme Court decisions on the matter. You must be aware of Section 15 and Article 61F, Section 15 of the Electoral Commission. Let me begin with the Constitution. Article 61F of the Constitution, which states one of the functions of the Electoral Commission is to hear pre-election complaints after nominations about nominated candidates and other matters. That must be read together with Section 15, which provides of the Electoral Commission Act, which provides for the making of complaints to the Electoral Commission, and how those complaints are made is provided for under Rule 4, 1B and 6 of the Parliamentary Elections Interim Provisions. Appeal to the High Court from the Commission Rules. SI 141-1. All matters touching election nomination papers, whether they were valid or not, you must file them before the election is concluded. Once the election is concluded, you can't challenge a nomination paper. That is in line with the several decisions which I'm going to refer to in the course of my discussion. Which you must be aware of is now academic qualifications. Very interesting. Academic qualifications. In the case of Maende Stephen Dede versus Honorable Abdu Adidwa and the Electoral Commission, Election Petition Appeal number 24 of 2021, the question was the academic qualifications of the Honorable Member of Parliament Adidwa were challenged. Indeed, he did not have clear academic documents, including Senior 4, not even P7 or Senior 6, but he brought a diploma in recycling of garbage. It is not laughing. So, judge held in the lower court, he held in the lower court that that the matter of academic qualifications of the respondent ought to have been handled in the pre-election period by complaint to the commission. We had complained to the Electoral Commission and it didn't make any decision, instead referring the matter to police for investigations. What would you do? The Court of Appeal, in a very detailed judgment, the Court of Appeal in a very, I want to quote verbatim, in a detailed judgment, the panel, I should not, I think you will find the panel yourselves, held that academic qualifications must be pre-election matters and must be challenged under Section 15 of the Electoral Commission Act, and the rules which have cited appeal from the Commission rules. Election petitions appeal from the Commission rules. We had cited the case of Abdu Barangira Nakendo. This was a Supreme Court, Abdu Barangira Nakendo versus the Electoral Commission, and another, which was a Supreme Court decision. We had also cited the decision of Kasibo Joshua. Let me see the correct citation of Kasibo Joshua versus Imbogo Keze and another election petition appeal number 10 of 2011. These two decisions of Abdu Barangira Nakendo versus Patrick Mwonda and another Supreme Court election petition appeal number 11, Supreme Court, it is a 206 petition, I think. I think it was the judges here didn't put a correct, where the Supreme Court had held that failure to challenge any matter before the election was not a bar to challenge the qualification or any other matter relating to the nomination of a respondent after elections. But the Court of Appeal referred to those decisions and cited the case of Kasirie Zimura, which is a Court of Appeal decision, Kasirie Zimura Fred versus Vazigalirao Chibuka Francis Amot, election petition appeal number 1 of 2018, where it had held that the election, like a river, some pre-election matters must be challenged by filing a complaint to the Electoral Commission, and therefore the petition was disallowed. It sounds strange, but now that is the law. If you don't challenge the academic qualifications of a person or his nomination papers, you will be closed out on the strength of those authorities. The other thing is filing, maybe I will highlight just the filing, you know. Filing of election petitions has serious procedural matters. And one of the roadblocks was faced by Mr. Semuyaba in the case of late Kasam Kaleganjuba, in the case of Sita and Sebaru versus Sam Kaleganjuba, number 26 of 20, election petition appeal number 26, Supreme Court appeal number 26 of 206. Before you file, you must know the processes of payment of fees. Fees must be paid for the petition with a prescribed fee and the attendant affidavits. Now, there was a decision, Amama Mbabas versus Garuga Musinguzi, 202, Court of Appeal. It had held that failure to pay fees that a party could pay fees even after the judgment, and failure to pay fees was a mere technicality. Then in the 206 election petition appeal, I think Kabumba was talking of the inconsistencies in Ndaula versus Naduli. Moses Ndaula, I think, versus Haji. Ronald Ndaula versus Haji Naduli. It was held that failure to pay fees was not a technical matter, and it went to the root, and they cited a certain KB English case in the KB. Then in Kambasale versus Namuyangu, which I handled, many of those cases have been appearing in, I appeared in them. In Sale Kamba versus Namuyangu, election petition appeal number 11 of 2011, the court did also reiterate, I think Justice Stephen Kavuma, who wrote the lead judgment, they said that even if somebody had not paid or had paid late, that would not arise. Now the other thing is the service. There had been tactics, service of the petition, because they say you must serve within 7 days. And the early authorities, when you read those pre-206 authorities, would say those provisions under section 62 of the PEA are mandatory. If you don't serve within the 7 days, you are closed out, your petition should be thrown out. Sitenda Sebalu versus Sam Kaleganjo, but the Supreme Court said that the provision in section 62 on service of the PEA were mere preemptory and not mandatory, where it interpreted the word shall, and when it should be interpreted as mandatory, and when not, and authorities have been thrown in ever since then. But you will also find some deviations in some judgments I don't want to refer to. One time we were arguing before the judge, I don't want to mention, I cited 7 authorities, and the other lawyer cited 7 authorities on the same issue, filing affidavits. When do you file? In Isataligora, they say even if when you had filed 3 or 5 affidavits and a reply or an answer had been made, you were free to bring in more affidavits because election matters, you look for them. Then in Yusuf Mutembuli, the music changed, and they say once you don't file the affidavits, Yusuf Mutembuli versus Nagwom Moses, once you don't file the affidavits together with the petitions, that was 2011, there is an appeal, I think in 2012, number 44 or 42, Mutembuli Yusuf versus Nagwom Moses. You must have studied it at RODC. I argued that case. So they said once you don't file, and they even said you can't file a rejoinder, because a rejoinder, affidavits are evidence, and the Parliamentary Elections Act, Parliamentary Election Rules, Rule 15, which says all evidence in election petitions shall be by affidavit. So the court said you can't even file rejoinders to what has been replied to. You said this one has said he didn't steal, actually he gave a bribe. You get the point? Are we together? Now you have filed 3, 4. You are maybe some seasons we were handling my Stephen versus Honorable Cheng in Jinja, and it was a rainy season, and all the witnesses, it was a village constituency where in gardens you could not find a witness until the planting season ended. You get the point, until the planting season ended. But the judge said you will not bring any other affidavits in answer to the petition, and we remained with only one affidavit. Luckily we won, because why? That in that petition when they were alleging in the petition, I'm still on filing, that this one bribed so and so, they were not indicating that the person bribed, A, was a registered voter, B, the money was given to induce him to vote, and C, the other things you know. So you must know when you are filing a petition on grounds of bribery, they rarely, unless you know the judge, they rarely succeed. Those on bribery, they were nipped in the bud in the Namuyang versus Kambasale. Because now, in that case, that appeal number 11 of 2011, Kambasale versus Jennifer Namuyang, the persons who came were people who received the bribe. You should also take note of which witnesses to bring with the petition. So the court said, somebody who received the bribe to do what? To ditch the other candidate cannot turn around and say, now I am with you, the other candidate, I was given a bribe, I actually voted because of the bribe. That's one of the ingredients, and that it actually voted. So now, where will you get witnesses? But with the video, we took videos in Ibale Joseph, Ibale versus Abdu Katuntu. That was 2011 still. When the Honorable Abdu Katuntu was giving a horse, was committing electoral offenses, you know what they held? They relied on Chemonges again. And they said, when you bring audios and videos of a bribe, you must take them to Makerere for transcription and translation. Even after that, the person who transcribed and translated must also come and give evidence. Beware. That one was Chemonges versus this and another electoral commission. Mr. Mutembuli was in that case. And after reading the judgment, he did a very funny thing. He geared and went out. But during those days, the contempt writs had not become... We were allowed to be stubborn, but even me now, when I must even fold my hands so that the judge does not say, you are putting in one of the matters. I think the judge was trying to, judicial officer was trying to ask a bribe indirectly from me. He said, next time, don't move with your hands in the air. Always move with your hands in the Chinyamatama versus this and another, and all the decisions, Asha Naburo versus Nambozo, now a state minister, and several others, were summarized in a very funny case. I used to teach at Erodis, and wherever I would mention it, students would laugh. That case is Apama, Borowa, Apama Amato. Why are you laughing? Borowa, Apama Amato versus Abiga Kanya. I don't know whether I am reading it in Rusoga. It is election petition in number 2 of 2021, High Court at Arua. Justice Boniface Wamara summarizes the effect of a lawyer filing a petition without a valid practicing certificate, commissioning without a valid practicing certificate, and so forth. And he cites several other decisions that might be of interest for interest of time. That case is very good. But borrower is not the real borrower of the bank. Borrower is B-O-R-O-A. Borrower Apama Amato versus Abiga Kania. Kania, when you take it in Soga, it might not sound well, plus Apama in Uganda, Amato, but those are somebody's names. I don't want to bore you this evening, so I must put in some Bonabaseke so that we move together. So I have already said, when do you challenge academic qualifications? Now, cause of action. Again, it was a very serious issue. In Maende Stephen Dede versus Honorable Adidu Abdu, there was a preliminary objection that the petition did not raise a cause of action. And the lawyer cited Auto Garage versus Motokovu, number 319. And he said the cause of action, So when I argued in the Court of Appeal that the judge determined that question on a wrong premise, because a cause of action in election matters is statutory as opposed to a common law cause of action. The statute says grounds on which you can, I think section 61, for you can challenge an election. One, irregularities, malpractices, illegal practices, and academic qualifications. So I was saying, once you allege those, any of those, then the remaining matters become matters of evidence for which court cannot engage in at a preliminary point. And again, I was overruled, and I respect that decision. And I mean what I'm saying. So, you know now, under section, who to file, section 60, either the candidate or a voter with specific signatures. Now, we were in Masaka, in the case of Namaganda Susan, the deceased wife of Mukasambide, versus Halima somebody. And Halima had filed against Namaganda. She had a few signatures. Then the next day when we raised the PO, Council Mugisha, I think, now is in Kampala, used to be in. He said, no, what these people did, they pulled out part of the papers on our signatures, and we said, apana. The numbers of the names, you began from 1 up to this number. So which numbers are missing? And the court agreed with us. When you read that case, a decision of Justice Elizabeth Msokeje, as she then was, now Justice of the Supreme Court, and the case of Gaga Warawambuzi versus Kenneth Rubogo, and another by Justice Angirin, retired, as she then was. You will know all the preliminary matters you would wish to know in handling, because also that petition, we defeated it on preliminary matters, although it went to a full trial and cross-examination. One thing I want to say before I move on to recounts is that you should be very careful when drafting affidavits. If you don't take the witnesses to the commissioners to hold the Bible or the Quran and affirm, and to see the color of the commissioner, I know Otieno, Senior Counsel Otieno, he was my lecturer at Terodi, lost 100 affidavits in one day. They just brought all the witnesses, say, how did you sign the affidavit? They brought it to my home and I signed. That one is dead. Vamwine would say, they took us to Jinja to sign. That one would render your affidavits dead. Why? In line with the decision of Kakoza John Baptist versus the Electoral Commission and another, he said that one is a court of appeal. It went up to Supreme Court election petition 206, and several other decisions like the one I've said, Gaga Warawambuzi versus Kenneth Rubogo and another. You will find that your affidavits will die a natural death. Very many lawyers don't pay attention to this. You bring a witness, they ask, well, can you describe how you saw this? But there are exceptions, like this decision of Panado. I don't know what his name is. That MP called Mugema Peter versus somebody in Iganga, Court of Appeal. Because say you didn't go to Kampala. Commissioner was in Kampala. So the Court of Appeal said there is nothing which would prohibit a commissioner to travel from Kampala to go to Iganga to commission. So you can raise such arguments if you find that they are. The other tactical area which I want to hint on, the rest my colleague will handle, are the recounts, applications for recount under sections 56 and 57 of the Parliamentary Elections Act. Recounts are done by chief magistrates. But the beginning section is the fees. Section 56, you must pay the fees. And you must also pay attention to the time, I think under section 58, or to the time within which to make a recount. If you apply for a recount today and the application is not heard within 2 days, that process is dead. Even if they bring the boxes, don't continue. And if I've made slight mistakes on the time, you will remind me. 2, there are no recounts for local government elections. No recounts for local. There is a decision by Justice Sekana, but we raised the PO before the chief with my brother Julius Turinawe, objecting, and she ruled even amidst such decision, she will go on with the recount, because I think section 97, section, is it 92, which says you, where the local governments, no, it is a section, the Local Governments Act, which says where it is silent, then you revert to the Parliamentary Elections Act, but it is now settled, no recounts for local governments. Now, if you lose a recount, there are 2 or 3 ways to handle. Once an application for recount is allowed and you are defending, most lawyers plead that, which I don't advise you to do, but it is available. You wait and have some goons at the court. They did so in Masaka, they did it to us in Ichobe, in Iganga, and one just breaks one seal of the boxes. Once one seal is broken, the law says you cannot conduct a recount. I think Winnie Byanyima, revision number 19 of 202, and Kasivante, yes, versus Singh. Katongole Singh, yes. The other options, because the sections do not provide for appeal or revision, but when you read now, the first case was, I think, Civil Appeal number 19 of 2011, that is the Kambasale versus Jennifer Namuyangu, they are in the High Court. Justice Musot, as he then was, said once these sections ceded jurisdictions to the magistrates' courts, then section 220 of the MCA would be applicable and the matter can be appealed to the High Court. And in revision cause number 02 of 2011 still, that is Sarah Mwebaze versus who? When you enter it, you will see Sarah Mwebaze versus, I think somebody, Ruth, they said that even a revision under section 83 of the CPA is acceptable. That is what the little I can share with you, but there are so many other things you have to be on the lookout for.
Thank you.
But the last thing I can say, when you file a petition or defend it, you can't be guaranteed to win or to lose.
Let's give a hand clap to Councillor Kamba. He has in the minutes given to him tried to tackle the key areas for you to be able to appreciate before you file your petition. Time never allowed him to break them down in detail.
Just one more thing, Mr.
Nangulu Eddie. Yes.
Nangulu Paul,
Nangulu
Eddie,
yes,
Nangulu
yes.
Eddie pulled the bread from my hands when I appealed against the refusal of a recount, and for me I thought it was a clear cut, because in one of the polling stations there was a clear change of results. The other one got 36 and he added with a black pen. This 36 was in blue. He added with a black pen 1, and in words it remained 36. And the man was declared. I would have won him with 97 votes, but because I'm always unlucky, even in Anguru gave me a bloody nose in that matter. I think when you go Kamba Hassan versus Macho Joffrey, you will see a decision even barring me from filing an election petition. Because this one won very well, there will even be no need to file a main. So I have been a victim of circumstance, but I also respect that decision. And I mean what I say.
Thank you so much. Indeed, we had that matter there, and Kamba was a victim of his own tricks. I want to invite Councillor Alfred. Alfred, you have depth of knowledge. Kamba has touched many of these areas here. The pre and post pitfalls that may occur. In about 5 or so minutes, kindly.
I don't know if I can do it in 5. First of all, I think let me tell you how I got here. I came here to get my CLE points. And I heard that there was a cocktail. So when I was getting registered, I ran into Kamba, and he insisted that I should. So you will not hear a lot of decisions flying out of my hands. But one thing for sure, there is no lawyer who has lost as many electoral disputes in court as Kamba. I know this for a fact. Partly because most of the losses were against me. So his account tends to be depressing. So I figured you might as well hear from someone who has won almost all of them. So I'll just add a few things. I'm also happy that there's quite a number of lawyers here who've done a lot of practice in this area. For me, I've been in it now. This is my 26th year, 26 pieces, most of it in this area. So I'll just add a few things. That area of pre-result dispute resolution by the Electoral Commission in Section 15 and Article 61F. Now, we heard from Dr. Kabumba that going to court now, you're just really throwing a stone in the bush, right? So one area that has not been tapped fully for me is that area of pre-election resolution of disputes by the EC. The Electoral Commission does a lot of handling of disputes, and you can actually get remedies at that stage. I had a client in 2021, I think. She had 10 other candidates nominated with her. And so we filed 10 complaints at the Electoral Commission, and they were all successful. The hearing lasted 3 days. She is now the Speaker of Parliament of Uganda. So, just to let you know that that's an area you can tap. Now, I also want to share something that is slightly different from what Kamba has suffered. Sorry? The complaint now we have is that the precedents are not consistent. And that the judiciary needs to clean up its act. But I can tell you in 2001, when we did the presidential election petition, we were looking for precedents and we could not find any. So if you read that judgment, we were combing from mostly Nigeria, the Commonwealth. So Malawi, I really don't know what has happened. Now we have a lot of precedents and we cannot even be consistent. It is true that there's a lot of inconsistency. I, for one, I was one of those who actively campaigned for single appeals to the Court of Appeal, because we used to have second appeals. And if you read those decisions from the Supreme Court, Kamba cited a few. There was nothing inconsistent about them. They are still good law. It's just that the Court of Appeal and the High Court, they have either ignored them or diluted them or departed from them. It's something you never hear in law school, that there's a departure by the Court of Appeal from a decision of the Supreme Court, but here we are. So I wanted to point out that we had a drought of precedents in 2001. Even 2006, we did not have precedents. So we're all over the world looking for precedents. Now, apparently, we're running away from our own precedents. So you have to have both sets. And if you're handling many election matters, you will use the ones that favor you in case A, and then use the other set in case B. And if you confuse the judge enough, chances are there will be an evaluation of evidence and not a single one of your precedents cited. So now we have judgments that look like novels. Now that takes me to the decision of what type of electoral lawyer you want to be. My friend Kamba is obviously a lawyer for technicalities. Filing, service, what was the other one? That may explain the number of losses, actually. I, on the other hand, because I was at the Electoral Commission for almost 10 years, I was and still am a lawyer for substantial arguments. Now, for you to be able to do that, the first thing you must remember is that the electoral process is a whole process. The one we're going into now started about 4 years ago. So you could attack the register. If you are talking bribery, for instance, your first stop has to be the register, because an unregistered voter cannot be bribed. You need to be able to prove that. And you need to be able, obviously, to prove the effect of the bribery. That's correct. Okay. So this filing and commissioners, Kamba's argument, to his point, and there's authorities, as he has said, that support that idea, is that the commissioner must have a PC, you must have a PC. That's true, but in 2021, I actually had 6 petitions dismissed on this point. But all of them went to the Court of Appeal and all those decisions were overturned. And so we ended up with a retrial. And then we ended up with appeals arising from that retrial. It's a complete travesty, but that's what happened. But there is an amendment to the Advocates Act of 2002 that says if the commissioner did not have a PC, the court can actually order for that evidence to be recommissioned. Now, that's the 2002 amendment, but the lawyers will have technicalities and the judges who have technicalities, over 80% actually, at least in 2021, simply ignored it. So it took about 4 years for that to be resolved. So you need to keep an eye on that. The best way, obviously, is to avoid doing business with a commissioner without a PC. I saw something about ethics. Can you imagine a lawyer coming to your office and taking 50 million to commission, I don't know, 2,000 affidavits, but did not have a PC? And he exists. He could even be in this room. I haven't seen him. It's crazy. Yes, because if you're doing about 20 petitions, chances are he's going to ask you for that amount of money, you know? Because it is possible that the commissioner can't be summoned to court. So you need one who, you know, can also come to court. But that's what happened. I'm just picking on things because I was given very little time. This thing of filing affidavits, apart from the technicalities of affidavits, which my friend has discussed, because you are tied down to trial by affidavit, you need to do two things. The first thing is you need to decide what your case is from day one. A lot of the politicians, like my brother, Honorable Seungu, the teacher, will just come and say they're dissatisfied with the result of the election, and they just want you to file something. That doesn't help. And most of them will show up 2 days to the deadline. And obviously, they're very loaded. They come with lots of money. The problem then is you have maybe a day to decide what your case is. So most times you just file everything. You get all the grounds in the law, and you put all of them there. And you have a short window to prepare affidavits. So you have 100 affidavits, but they are talking about 80 different complaints. You have no nexus, you have no corroboration, but you have huge volumes of evidence. That's not a case that you can win. So you need to focus your case on one ground or two. And if you're talking substantial justice, which is what I generally advocate for, you need to have decided your case before even you file it. Now, there's this filing by voters. I don't think you touched on that. The candidate can file, but obviously a registered voter can also file. That's very troublesome, because you need, I think it's still 500 for members of parliament, registered voters, to support that petition. Now, the law gives a very thorough set of requirements for each of those. So keep an eye on that, because if it's not compliant, the petition will not have any leg to stand on. I think I lost one of those somewhere in maybe about 2016. But the most important thing I can tell you, I think, is If you want to practice in this area, you need to prepare for it. Physically, you can see I'm very fit now. I wasn't this fit last year because come January, I need to be physically ready and mentally prepared. I can give you, and the other thing you need to do is clear your backlog now, because it's going to be 6 months of nothing else. It's just politicians, their money, witnesses, and a lot of travel. In 2011, I think, I had everything when I showed up in Bali at about 2 a.m. There was everything in the car, except my suit, which I forgot, I think, on the chair or something. But I also got to know that I did not have a suit in the morning, not at 2 a.m. when I checked in, for a case that was in Soroti. So the idea was to rest in Bali and then drive to Soroti, which is, I think, an hour or so. So 4 a.m. is when I realized that the suit was all the way in Kampala. Now, Mbale has one lawyer that is almost my size. He's called Obedo. So I talked to Alfred Madaba, who called Obedo, and Obedo sent me a suit. The problem was the color of the suit. Anyway, that's how I showed up in Soroti in a pink suit. The first person that raised the PO was the judge. It was just not pretty at all. It was pink, it was kind of short, and a bit too big, round about the belly. But the point is, you actually have to prepare for it and clear your backlog so that you don't travel to Mbale at 2 a.m. Rather, you should travel to Mbale the day before. You can't go around that. And then finally, now the number of courts has increased. There's now High Court in Karamoja. There's one in Patongo. I don't know which other one is. So you can no longer afford to take cases like my friend here from Mirama Hills all the way to Agago. You can't, because it's not going to be practical for you to be in these places. So you have to turn down some. Or for that matter, try and create maybe some working relationships with lawyers in different places. If the Attorney General was here, I would have told you a story about his escapades in 2011. But since he's not here, I'll not be able to share that story. But try not to take cases across the country in this area of practice, because you'll break down, but also because your clients will not be able to see you. So I thought I should just share a few of those in the area of preparation.
Maybe Alfred,
as you go into it.
Yes, as you wind up, you spoke about the speaker among. You have known that our opponents have been struck off the register. Now, in advising lawyers here, when is it the right time to start the practice of petitioning? If you must advise a client, is it at the point of the elections? Is it much, much earlier? Or when is the best time to advance your attack?
Okay, so there is the litigation part of it, which you will not be able to file anything in court before the Gazette is out.
Yes.
Because the law prescribes a period but the commencement of that period is from Gazette for all levels. But that's if you're challenging the final result of the election. Now, if you're challenging the nomination, which is the candidature, obviously that the cause of action would arise from the actual nomination. But if you're challenging the electoral process, which is where you're most likely to win actually, in the end, you're even late now for the general elections, because your cause of action can arise from the registration. If you're trying to challenge a candidature, obviously you cannot be a candidate if you're not registered. So you could be filing now to just even get a declaration that this person is not registered. What that means is that the person would then not even show up for nomination. But there are even those who owe costs from long ago. You should be petitioning for bankruptcy now, because a bankrupt cannot stand for election. So it just depends on what your cause of action. But in terms of political strategy, you can always find a cause of action to deal with the political opponent as a lawyer. So if I was talking to politicians, I'd be telling them that they should have hired and paid their lawyers 6 months ago. So that we're already preparing the petition. We're just waiting to fill in the aspects that relate to the electoral process, counting and tallying. I don't know if I've...
Yes, thank you so much. Let's give a hand clap to Councillor Alfred. He didn't have much time, but he has done justice to his area of discussion. Let me pass on the baton now to Councillor Semoyava. We have walked past the pre and the post pitfalls. What I want to ask you is guide the members here on proof during petitions. How do we balance the tests? How do we balance the technicalities and justice in Uganda's democracy? So if you would venture into that area there, let me just rephrase the question. What is your view on proof during petitions, and how and on balancing technicalities and justice in Uganda's democracy?
Thank you, Mr. Nanguru. Welcome, everybody. First of all, I will start to make the record straight so that we are not accomplices, all accomplices to the crime. If any scene of crimes officer is here, he should record it properly that I was invited to speak in a democratic governance conference. It has CPD and CLE points for members to attend. It is authorized by law council as one of the as certified training programs, and I badly needed 5 points. The year is ending, so I had to attend. Then I heard that there are some beers, so I need to take some few beers on a Friday evening. Scene of crime officer, record that. So that we are not all accomplices to a crime. Then I understand I'm also attending with Mr. Council Munavi, who is on the other side. Okay. Thank you. I'll answer the questions that you posed. Like I told my neighbor who was here first, Dr. Kavumba, I was telling him that, of course, for them, they're always in the academic world, teaching. I now pity the lecturers, because you teach the law as it is written. Now, when the student comes out in the field, he will first have to read a book called What I Wasn't Taught at Yale Law School. Because if you don't read that, you'll completely get mad. So what I'm going to talk, I'm not going to talk precedents. Because the precedents are there. Be sure they are not followed. Be sure they are skewed. They are changed every day. A judge will have 3 judgments and he will say, he will look at you and say, now this one, which precedent do I use on him? So you'll one time collapse in court, be sure. So I'm just going to talk about courtroom drama, what happens in an election petition. A lot of drama takes place behind the scenes and in the corridors, on the road, on the what. Like Mr. Kamba said that his suits were stolen in Mbarara. Our first election petition, all of us were still amateurs. I did it with him. We were representing Honorable Agra Ori. So we go to sleep in Busia. At 3 o'clock, Honorable Agra Ori calls us and says, my intelligence says you are going to be attacked. Leave the lodge straight away. We had to pack imagine packing things, just carrying books like this, and we sped off. We slept in Agra Ori's sitting room on the floor. So that one, you won't be taught about it in law school. You won't find it in the statute books, but you will be attacked by the opponent. So your security, you must be careful. No lecturer will teach you about that. Your car will be waylaid. Even your books or your files will be stolen. It is not taught in law school. Now that comes to the topic I've been given. Then if your files are stolen, then how will you prove the case? So the smart opponent will steal away all your affidavits, all your files, all your gowns, all your suits. And by the time you reach court, you have no proof. So because election petitions are proved by affidavits, very, very important when you're drawing the petition to ensure that, of course, it sets out the grounds of setting aside an election, as other speakers have said. But then when it comes to affidavits, that is, again, where the problem starts, or many people make mistakes. Just like Mr. Carol Yema said, we normally forget that election is a cycle. You must go and look at the Political Parties Organization Act, the Electoral Commissions Act, the Parliamentary Elections Act, or the Presidential Elections Act. You must know that the election cycle started a long time ago. We are actually now into the campaign stage. I don't know which stage it is. So the election has got cycles. Now, as you're drawing affidavits, you have to remember, is this person you are taking to court as a witness, is he a registered voter? You have to ask this person for a voter's card. You must ask them for a national identity card. And be sure that the smart lawyers who have been in this business for a long time will cross-check. There are so many databases where identity of people will be checked. Electoral Commission has got a voters register. NIRA has got a database for national identity cards. Remember, the voters register is developed out of the NIRA data. So before you become a voter, you must have been a national identity card. Elsewhere, they can go and check for you in the passport office. They can even check for you in the bank and all that. Now, if you forget about the fact that you must plead that your witness is a registered voter, you are going to fail to prove so many things. Like you've been told by Mr. Carol Yem. How do you say I was bribed when you are not a voter? How do you say that they stole our votes when you are not supposed to be into the electoral process? How do you say you are registered in Entebbe or you vote in Entebbe when the voters register is showing that your registration is in Kasese? This is exactly what I'm seeing. I'm reading about this story in the media, but I'm seeing, sorry to mention the big person's name, but Honorable Anita Mong, I can see the dispute is about opponents. They are not registered in the constituency. They will cry around, but you see, the moment they go and find you that you are not registered in the constituency where you are going to stand, you are out. Simply because you forgot to, Electoral Commission keeps on announcing and calling people to update the voters register. Even NIRA is calling all of us. I'm sure many of you here, if I ask you to put up your hands, do you have an updated national ID? I'm sure there will be very few people. Such things come up and you end up finding that you are swearing affidavits. You are taking affidavits to court of people who are not registered voters. Mr. Okero Riem, Mr. Okero Riem, who normally gets on the pan of the biggest case, I think will agree with me that in the last petitions, I think you are going to have many of affidavits thrown out, because you see people have a tendency of going and forging around these things. They go to Nasa Road and forge a voter's register. They go to vote a national identity card. The government or the institutions, the electoral commission, has a lot of capacity to cross-check. And there are a lot of databases these days, by the way. You play around with your card, they will check in NIRA. They will go to the passport office. They will go to registration of birth and death. So in order you, the lawyer, not to embarrass yourself, first ask these witnesses about a lot of this. Me, I must confess, the last election which we had during COVID, lockdown, and there was that, the wave. You remember the wave? The last election had the wave. So the petitioners were coming with many witnesses. I can assure you, you sit down, you ask this guy, have you ever, do you have a voter's register? Sorry, do you have a national identity card? And the guy completely tells you he doesn't know a national identity card, but he was in a wave, moving around. He's now complaining that the elections were rigged. You say, how do I take this person to court? So, because you're going to embarrass yourself, they cross-check. Electoral Commission cross-checks. And it's easy to cross-check these things in computers. Then, like swearing affidavits, Mr. Kamba has talked about commissioning. You have to be careful about where you commission. Normally, the tendency of lawyers during election petition litigation is, this time, I don't know why they work so hard. They come with all kinds of objections. Be sure that your jurats or affidavits will be challenged on the basis of whether your witness ever went to a commissioner for oath physically and sign and swear. And there's a set precedent, Kakoza versus Electoral Commission, where somebody signed an affidavit in Kampala and I think signed it in Masaka. Then the commissioner for oath was in Kampala. The court has already set a precedent that such an affidavit has not been properly commissioned. So those are things you have to be careful about. Then another practical bit is affidavits will be lost if the witnesses, for example, are called for cross-examination and they don't turn up. Several precedents, there may be other differing, but me, I remember last season we lost an election petition because when it came to saying, okay, bring witness 1, 2, 3, 4, 5, now behind the scenes, like I said, you are not taught in law school. Your witnesses will be given man and they won't turn up. So the court will expunge that affidavit. I advise most of the clients, petitioners, that on the day of the hearing of the petition, and we did it in Busia, get the witnesses and put them somewhere so that you have them for about a week. Otherwise, you'll get surprised when the judge says, bring witness number 1, you call in the morning and the guy tell you, I'm not in Kampala. He has, and they eat very little money, 50,000, 10, 20. And the guy decides, then the judge will expunge that affidavit. So these are some of the things that I said, courtroom drama, that is not written in the law books. Evidence, proof of winning a petition is not about just filing it. You must always remember that in the final result, is your client able to prove that there will be a substantial change in the result? You know, you must read very well about the qualitative test and the substantiality test as enunciated in the Amama Mbabazi cases, that, for example, if the other party got 30,000 votes and your client got 20,000 votes, are you able to demonstrate to court that the difference of 10,000 votes can substantially change? Otherwise, you'll waste a lot of burning your midnight candle pursuing a petition when at the end of the day you cannot prove that. Exactly. Yeah, so that you at the end of the day the court will say, this man has got 30,000 votes, your client has got 20. How does that result change? Even if you have proved so many things, you must not forget that in the final result, the substantiality test is weighed. These days, there's a lot of electronics. So be able to read about how electronic evidence is going to be adduced, because most of the clients will bring you recordings, WhatsApp messages, etc., etc. So during the trials of these days, a lot of electronic evidence will need to be adduced, videos and whatnot. Mr. Kamba has told you that you have to read the Electronic Evidence Act, which requires transcription of electronics before they are adduced. Then I've talked about safety of yourself and the safety of your witnesses and your opponent. You must think about it. Some of us who have been a lot in some of these things, you must be ready to walk when people are pointing fingers at you. Akasajako, umukazo, because you see elections are so, what word should I use? They are so emotionally charged that, for example, when you are very, very long, you have spent long in these things, the public will start looking at you as if you are the cause, you are the one who is causing. And you see there's a lot of suffering in society. People have a lot of things on their heart. So be careful about your safety during these election petitions, because they are so emotionally charged. You can be killed or you can be harmed. Then I've talked about recounting witnesses. Then finally, much as our society is getting rotten in all aspects, in all things, as a lawyer, try to keep integrity, because it is the price that it is the only thing we shall have to remain with. For example, try to be independent from the dispute of the clients. Me, I've trained myself to eat. Of course, many people will blame me or not or what. The dispute is the politicians. You try to be a neutral. Because at the end of the day, they are your friends also. You are meeting here and there, you are meeting them in church. You'll be surprised when you go to a Kwanjula, you are petitioning the other side. Now you're a family. So you as an advocate, I think it's very important to keep integrity and keep an independent mindset from the election dispute. By doing that, by the way, you will be able to independently judge. Like, I think Council Elson is here. He's the one who gives us those Twitter spaces. You call it what? Yeah, those conversations. But then there's something you say. An advocate, you judge. These judges are not judging for us. So you judge your case. Read your case and judge it before you take it. So that you are not annoyed by the judge. Is your Me, I was telling members of Law Society that what is the solution of the quagmire in which we are? Why do you go to the judges? Why don't we sit and we judge our case? So that we stop getting annoyed. We stop getting annoyed with the judges. We judge our case and we say, Munavi, you want to be a council member, be there. Nani, you want to be this, be there. So that you don't go to in the morning you wake up and say, the judgment which is coming out, there's a judgment, let's judge our case. Because the judges are not ready to judge for us. So, thank you so much for inviting me here.
Thank you so much.
I came to earn my points and take some beer.
Another hand clap. Hand clap, members. We shall have a few questions run around. I know we don't have a lot of time. When the sun sets, it is time for beer. No matter how good the topic may be. Okay, for those that take tea, we have tea in plenty as well. I want to just say, let me first read out this one here. The people who have parked badly, please, if you could just allow us to create some space. The driver of UBP 363H, UBA 824C, UA 990BC. Please just create some space for people to be allowed to move. I want to ask some questions, but I am caught for time. Senior Kamba, I won't give you time. I'll give you time. I want to first pass on the mic to Professor here. We are trying to beat the clock. When it gets to nightfall, all your good points may be forgotten. For you, the question is this. What is the role of lawyers in upholding democracy and safeguarding civic rights in the electoral process? As quickly as you can.
Yeah, sure. Don't worry, I'm going to be very precise. I know we've run out of time. I see every speaker here begins with a disclaimer. I concur in all the disclaimers in relation to the purpose of this meeting. I also came for all those things that the previous speakers have stated. To answer my question, I'm going to do three things. One, I'm going to touch a bit on the theory, which you accuse us of being very good at. But I'm also going to touch on the practice, and in touching on the practice, I'm going to give you two stories that pertain to me. There is quite a lot that lawyers can do in upholding electoral democracy. I've just listed them here. I'll just give you the list. I won't discuss them in detail because of time. But first of all, we make the laws. We make the electoral laws at different levels. we manage electoral processes. Our colleague here, who worked in the Electoral Commission for so many years, he was managing that process, Mr. Oriam. He was managing that process. We guide candidates when they are going for nomination and other pre-election processes. Those of us that sometimes do civil society work, we also engage in election monitoring, election observation. Again, those of us that are in legal aid, and my colleagues in legal aid here, you know that the season is coming where we do rapid response to rescue young men, especially that are arrested during campaigns and during election days. We usually set up teams. We usually set up rapid teams that respond to apply for bail, to apply for bond, etc. We litigate electoral processes. Council Semuyaba and Kamba, you know, are making a living out of that. We also, and this is where I'm going to tell the first story, we also push boundaries of electoral laws and practice. The year is 2016. The day is voting day for presidential and parliamentary elections. The campaigns have been electrified. Change is hanging in the air. There is a lot of excitement. We are entering a new dawn. As voters, we are excited. I want to cast my vote as soon as I can. I leave my house at 6. I stay in the Namgongo area. By 6:20, I was at the polling station. There were just like 3 of us. By 8, the crowd is swelling. There is a lot of excitement. I could hear such statements. Lero tumutwala, tumutwala. We wait. By 10, the Electoral Commission officials have not showed up. 11, they are nowhere to be seen. Now the crowd has become so big and is getting out of hand. Eventually, the electoral materials arrive towards 2 p.m. So that's just Kampala, just a few kilometers away from the Electoral Commission. It's actually a walkable distance. So, but anyway, we are not, the voters are not deterred. They must exercise their right to vote. So we vote. Some of the voters decide to hang around and guard their vote. They forego lunch. I decide to go home quickly, grab something, and then come back to guard my vote. I actually come back to guard my vote. I guard my vote up to the time the voting is closed and counting starts. We begin counting the votes. And my candidate is winning. And every time they mention my candidate, we cheer, we cheer. We go home knowing our votes have been counted and our votes matter. When the Electoral Commission begins to tally the votes, it gets to a point where it says, considering the results that we see here and the proportion of the votes, we don't think it's necessary to tally Wakiso. In any case, even if we added all the Wakiso, Kampala, and was it Kampala as well? It still wouldn't change the outcome. So what that meant is that my vote doesn't count. I left my bed at 6. You don't know the things I left in my bed that I forewent. But I found so many things and went to engage in that exercise. So, of course, the results announced a certain candidate as won. But I was so angry for the days that followed. And I was like, what can one do about this? There's an election petition. But remember, our law is the effect that the cause of action, an election petition, is reserved for persons that have taken part in the presidential elections as candidates. Unlike Kenya, where any person can bring a petition, presidential election petition. So I scratch my head. Then I remember my practice in the community law center in Cape Town, where we were doing amicus, and I was like, but can't amicus play a role here? We have to break the ground. I go through the amicus decisions, the precedent, they say you cannot be amicus in a matter unless you are invited by court. I even come across a decision where the judge says as a court, we know when we need friends. We shall invite you when we need a friend. So I was like, how do we convince court that actually we can invite ourselves in an election petition, presidential? And it was the first of its kind in the world. But anyway, we brave on. And then the question then is, what's the entry point? And that's where your role as a lawyer comes in. That's where our role as legal academics then came in. We thought then that our entry, we didn't participate in the election, we were not candidates, we can't say we lost an election even when my vote was not counted. But the entry point was, we looked at the decisions in the previous election petitions in 2001 and 2006, and the court had found a number of gaps in the law. The courts had found a number of irregularities in the law, or gaps that affect the quality of our elections, but nothing had been done. So we thought then, why don't we use our legal expertise to push the state through a court-ordered process to engage in electoral reforms? Because in after 2011, we had tried to push for electoral reforms. We even went to Parliament and made submissions, but none of the proposals we made was adopted. So we opt to ask to say, court, as amicus, our argument is we are having issues with the quality of our elections, partly because there are so many gaps in the law. So we then outlined those gaps. It turns out that actually that's the only good thing that came out of the 2016 presidential petition. That's the only good thing that came out of that petition. But besides that, that amicus application, of course, the court agreed with us. It reversed a previous decision, Silver Springs, that we shall invite you. It agreed you can invite yourself, but there are certain conditions you have to fulfill, which we did. But the court makes 10 recommendations that it picked from our amicus brief. And some of those recommendations were actually implemented. But the question then, as we were making the recommendation, I asked myself, but how do we ensure that these recommendations are implemented? Because we know we have a system where court directives are disregarded. So again, we scratch our head, and what comes to mind, I remember chapter 7 of my doctoral thesis was on the remedy of structural injunction. How can we twist it here and we have it applicable and we succeed? The court issues a structural injunction, the first of its kind issued by the Supreme Court of Uganda, asking the Attorney General to ensure the reforms are adopted and then reporting back to court. And the reforms were 10 in total, the recommendations from court. Not all of them have been implemented. The time of filing presidential petitions, initially it was 30 days. We proposed 60 days. What was promulgated is 45 days. At least we got something out of that. Article 104. We also made a lot of noise, Mr. Semuyaba and Kamba, on affidavits, where we argued that, cases of this nature, affidavit evidence may not be sufficient, that in some circumstances we should have oral evidence. Unfortunately, I'm not sure you could advise me whether that has been effected, but it has not. But we argued, and of course we saw that.
I think the recent decisions, the Court of Appeal,
yes,
have started being liberal about affidavit, whereby even if they say the affidavit has a problem, the court is saying, but the evidence can also be oral.
Yeah, sure.
So you shouldn't just throw out somebody's affidavit, because you could call that person to give oral evidence.
So at least we are achieving something. Because remember, there is a mischief to deal with. You remember the petition where affidavits walked out of a law firm? You remember? Where affidavits walked out of a law firm and they were seen walking and and then they disappeared in the darkness. The other achievement was with respect to the time of holding a fresh election, because we argued the 20 days in the Constitution is too short. And indeed, the court agreed with us, and there is an amendment that pushed it to 60 days, because we said, how are candidates going to campaign in 20 days? We made recommendations on the use of technology, not sure whether that has been done. unequal access to state media that has been implemented by amending Section 24 of the Presidential Elections Act, and so many others, including amending the Presidential Elections Act to remove an exception that allowed the incumbent to make donations. We now have a Section 64, which prohibits all candidates from making donations. The other was prohibiting involvement of public servants in political campaigns. So you can see we did that as lawyers, we did that as legal academics, and indeed we actually achieved quite a lot. Eddie, the second story, and this I'm going to end at this. After doing our amicus, I became an instant celebrity, not just in Uganda, but internationally. So in 2017, I was invited by the International Developmental Organization. It is an international organization that promotes rule of law, constitutionalism, electoral democracy, etc. I was coupled with an American professor, also fortunately called Christopher, to do two things. One was to build capacity of the Kenyan judiciary on the use of amicus curiae. Number two was to write a book on amicus curiae practice. And that was in preparation of the 2017 elections in Kenya. The other thing, myself and Dr. Kabumba is not here, we were involved in capacity building for judges of the Supreme Court of Kenya. They even gave me an accolade, which I have, in electoral dispute adjudication, which we did, flying in a judicial training institute and stuff like that, being picked at the airport by bodyguards, flying business class. It felt so nice. But this is where the story turns. We launched the book, the amicus book, on the eve of elections, the 2017 presidential elections. I've never told this story in many places publicly. We leave the country, and of course the election is annulled, and amicus is also, the amicus procedure is also endorsed by the court in Kenya. What followed, of course, you know, it was a contested outcome. The country was almost reigniting that, like it did in 2007. And a certain powerful group generated a list of people they described as architects of judicial capture. And my name was number 2. My name was number 2, and you know, they described a lot what he was doing, blah, 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 how he came in, blah, 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 blah. So it also goes to the security thing that Council Semuyaba has just spoken about. I spent close to 2 years. I used to be a regular traveler to Nairobi and also using Kenya, but I spent over 2 years without stepping foot in Nairobi. And probably if I'd listened to the lecture by, the keynote address by Dr. Kabumba, before that, maybe I would have gone and said, we go. Probably I would have. So we do the things, but they come with a risk. And we must be prepared for those risks that come with it, including security. But just to sum it up, yes, we can play a very big role. We can do the legal representation of clients that are involved in disputes. We can participate in the making of laws, but we can also break new grounds that result into everlasting legal and constitutional reforms. Thank you so much.
Thank you so much. A hand clap, a louder hand clap for Professor. Professor was equally ambushed. People don't know that some of our key speakers were cautious about the court order, and they thought, I can't be seen. These are brave men. Please let's clap for them. They, despite the disclaimer, to sit up here and be part of this event is monumental. So I would thank them. We are caught up for time. Councillor Kamba had something to say, and also Councillor Oriem. I was told that I can't be allowed to permit that. Members, the plenary shall be at the cocktail. These gentlemen are going to be around over a bottle of whatever you'll be taking. You can ask them whatever questions you would want to ask. So allow me relieve them of this burden here. Thank you so much. You can return to your seats. We are indeed grateful. Please, you can return to your seats. We have just 2 major items to do, then we can wind up this session here. Councillor Kamba, thank you so much. Please, you can now wait for your beers. You're going to have them in plenty.
Please, I'm a Muslim. Just save me the beers, please. If you announce like that, I might be chased away from the religion. So I will request you pay damages for that.
I withdraw that offer there. Let me invite Councillor Zander. Zander, just come for a minute. Zander is one of the most recent appointees on on the council. I want to he has just one simple task to do, and then we can get into the final stages of this engagement.
Thank you. I just have one simple assignment to do, and that is to invite the next keynote speaker, one Dr. Ekwaro Obuku. As Mr. Ekwaro Obuku is coming here, this is the little about him. He's a Ugandan medical doctor. He's not a lawyer. He's a medical doctor. He obtained his medical degree at Makerere University in 2003. He has a Master of Science in Clinical Trials from University of London in 2009, Formulary Committee and the National Drug Authority. Still about Dr. Ekwaro. Please, members, don't go. Let's wait for these few speakers and we're going to enjoy our cocktail. Mr. Ekwaro is also a member of the World Medical Association. Important to note as well, this is important to the speaker. He's a married man with 8 children and is a proud member of UPC, Uganda People's Congress. Can we clap for him? Mr. Ebaro, you're welcome.
Thank you.
Thank you very much, lawyers, for inviting me. Incidentally, I was supposed to be a lawyer, by the way. I just didn't pass literature, so my father defeated me. He was a doctor, and I wanted to do law, but I didn't pass literature in O level, so I had to do PCB. My mother was a nurse. Can you put up my presentation? So I'll be brief because I know I also am looking forward to for me, that's why I came. I said, these lawyers, I'll just talk a bit, I go and eat. Okay, so I'm going to talk about agenda setting and policy change and our experience. We tried an experiment which worked very well. And, I've just been learning a lot from this panel. It was so relevant. In fact, I've got free legal advice because I'm also running for office. So I've seen there are things you can do, there are things you can't do. Can you put the presentation to be consistent? Put it back up. I did a PowerPoint. I realized lawyers are very clever. They even don't do PowerPoint. They just talk from the head. And maybe that's why the judgments are the way they are. They are not consistent. Can you put it up? Me, I'm not that clever man. I want to be consistent. So as we speak, I had a lot of, here it is. But I wanted to tell Munabe that you people, you are so lucky. For us, we are always praising the Law Society. We want to be like the Law Society. All right? And when you challenge those things of your president, you become weaker. Our president once knelt down. And some of us say, no, don't challenge, So ever since then, once we removed him, we just went downhill. We introduced thieves in the executive, which was now worse than the one who was kneeling to beg for money. So be very careful how you cause transition. You may collapse. You may collapse and become nothing. And the Law Society is a fundamental building block for democracy. For us, it is to promote health and access for all. If doctors don't speak, who will speak? The patients. So we are looking up to you also. For us in the election, the politics side, don't you see the MP came to see what can he learn also and prepare accordingly. So this is a very, you promised me a lot. I will start with that one. And a picture has 1,000 words. He has a broom to clean the radical Nuba. And for me, what you are saying was music, because many Ugandans have had matters in front of courts of law. Actually, the first I went and looked for systematic reviews and said, a father's involvement is very important. But I didn't know that precedence, based on 1 or 2 case studies, is more important than a systematic review of 100 studies. Then I said, lawyers are too clever, I'm yet to understand. But that is the system. The other thing I discovered which you need to work on is time. Lawyers and doctors, we are responsible for people's lives. The first time I went to court, I was there by 8. The guy arrived at midday. I'm even lucky because we kept going back for the same thing. One time I arrived early, the guy never showed up. My mother has a matter in Kabale there on land. The experience is daunting, I can tell you. Until the judge, Semogirere, came. Yeah? You would travel and because she's married in the north, where I'm running for office, has to travel 500 kilometers. You reach there, the judge says, I'm not coming today. And you have to go 2 days before and stay there, prepare with a lawyer and so on. So those are the things you need to handle as a society. I thought I must appeal to you here, since this is the greatest concentration of lawyers I've ever addressed. I thought I would start doing law, but my applications have been dismissed in 4 universities. I've even been consulting Okuda. Where can I apply? Because my career is a bit tough. The other thing I need to tell you is do not be discouraged by the Munavis of this world. Because for him, when we said we are going back to the bush for him, he thought we are going to get guns or buku. Now you're a rebel, you are with FDC. He said, no, for us, we'll take you to the intellectual bush. You answer these questions. After that, he doubled the budget for blood. They even had so much money. We have excess oxygen we can now export. It was not Ministry of Health. It was the doctors of Uganda who said enough is it. So lawyers, you must say enough is it. Otherwise, sincerely, some of the judgments which come out, they are not consistent. We also read, we don't understand the law, we don't know any precedent. And sometimes even the English is not okay now. So our theory of change moving forward was Project 100. We said, can we field 100 doctors in parliament, in municipalities, in LC1, in mayor, what? We tried that experiment. Yeah? Now, the previous one here was Rugari Gideon. He's very famous. I think he used to work for the intelligence. And he's a doctor, he's a surgeon. But he managed to convince the president to give 10 billion to train doctors. advanced training, sophisticated. That's why you see we have transplant. We can now transplant the kidney by Ugandan doctor. But it wasn't the ministry. Because ministry, when it goes to finance, they are told, we are giving you $1 million. You decide what priorities are in there. New money can't come. And there are many things that have happened. Rugunda, of course, he was a yes man, and our brother Besije. He's also a doctor there. I visited him last week. I said, how is the situation? You all know. It is lawyers who put him there. You know that. It is lawyers who put him there. So it's lawyers to get him out. Because you're the ones who give advice to the powers that be. So it is upon you to get him out. All these are doctors. Because it is very obvious for lawyers to go to parliament. It is not obvious for doctors. But there is one question which is never answered. Many doctors say, health is so bad, but we have all these doctors there. From Kiseka, from Bukenya, to Kazibwe, then Rugunda, Kiyonga, all these doctors, but they can't even help us. All those years, it was until 2017 that we started seeing money which looks like for lawyers. You get what I mean? Consultants started earning money like for judges, but it's still not there. Because we took action in our hands. The challenge is the Law Society does not even sponsor two MPs. Yet you are here 1,000 contributing so much for CLE. Why don't you get Semakade and it becomes MP Kampala Central? Annual subscription, you do the amount plus 100, every lawyer. And Semakade just goes bombarding the money, because you see, you cannot win without money. And he enters the parliament and you vote yourself as a speaker who is actually a speaker, not a headmistress. Because I read has got a first class from KIU. I said, the lawyer really saying these things. The other is the deputy. I was with him in Makerere. Is he also a lawyer, the deputy? The other day he did something unbelievable. The thing was not discussed. It was not. I said, man, what are these lawyers doing? Lawyers, Law Society, Anthony, my namesake. Yeah? So I'm also standing, and we are doing an experiment. So, whenever I meet doctors, they say, Obuku, man, because of you, now I can get a loan of 200 million. We were earning 3 million. Now I'm earning 13. Then you tell him, I'm standing. He says, I'll pray for you. My friend, if prayers were working, pastors would be in parliament. But now, we are trying an experiment. Let us send our man to parliament. Do it for Semakade. Get some 3 lawyers. Try to field them. Who will go and speak for you? The lawyers who are there took themselves there. They have debts. They reach there, the moment 5 more passes, they grab it, then they say, please, we are passing the situation where, bail is no longer an issue. There is no way those laws are not going to pass, and even become worse if you guys don't take a stand and enter the mud. For us, we entered the mud, my friend. We never used to sleep home. You have to enter the mud and play the game the way it is played. You're not going to win an election without money, for example. And you must do that. Otherwise, the civil service, the people like you and me, are going to be in the periphery of society. In the next 2 election cycles, we will be a forgotten case if we don't take action. That is my honest view. I wanted to pay gratitude to Chapter 4. They would do pro bono services for us because we didn't even have the money as an association, as well as SEHAD. Now, I've finished really what I wanted to say, but let me just throw 3 more slides. Of course, you know all this. I won't say it to you. So who are we? Professionals like you. Okay? And the guy down there is the one who is now responsible for transplant of the kidney, Asimwe. He's our incoming president, hopefully. And you know, I was a bit jittery when he joined the team because he's the president's neighbor in the village. But it turned out to be a blessing because when Museveni said, Obuku, you come with your 5 people, I said, sir, I'm not ready. Because I'm an Okello, you might forget that the LRA didn't end. So when we reached State House, I said, now Asima, you first sit in front. So when the president came and said, hey, your mother taught me, I started relaxing. We could talk now. Because, you know, my uncle, Ogole, is the one who shot him. You get it? Ogole, the guy, because I visited the wife, my, in-law, and said, Ogole said his body shouldn't come back. So when the president came to say, you should know her, I said, you don't know him. Because, so we were fortunate. So when you are constituting your team, it is very important you have people from there also. They save you. Yeah? Don't go far without that man from Tungamo who may be knowing secrets. Those are our values, integrity. This one is lacking everywhere. In fact, as you are speaking, I could see it also among doctors. Integrity is a very rare commodity of late. You know this too well. But the most important thing I want to emphasize to you people is solidarity. Munavi, solidarity is more important than that case matter. Solidarity, when you have agreed that Semakade is the one, you first you give him those 6 months as you organize yourselves for a proper transition. You are better off together, even falling together, than dispersing. When you disperse this group, the other group, it doesn't help the society. Man, we have been admiring you. Keep it up. Don't become like the unions. The unions are so dysfunctional. The workers' unions, they are so taking bribes from employers, the Indians. I ran for election for workers. I couldn't win. It's a syndicate. It's too much. The worker has no voice, actually, in this country. And the lawyers are also part of, facilitating those processes where workers cannot be compensated. So solidarity is very important. We are there all over the place. What we do is advocacy. I may stop somewhere here. Problems have been identified here. Policies are proposed. But the politics, no one wants to touch it. This is where we entered, the deep end. And I'm glad the Radical New Bar has identified this. Because what you are trying to solve is impossible. Otherwise, why are you a leader? If you can't solve the impossible. We had no budget. We needed to make sure that when a doctor goes at night, a mother comes bleeding, you have blood. Otherwise, it is magic. Do you know how many doctors work in the rural areas? A mother comes and dies because there is no anesthetist. You know anesthetist? So the doctor is trying to be an anesthetist here while operating, going to check the eyes of the mother. Do you know the solution of State House was to institute something called the Health Monitoring Unit, which had powers to arrest. So when we met the president, we asked him, now you tell us which research has been done, or WHO guideline, which says that arresting health workers will reduce maternal death. Which cites any evidence, any research, and he was defeated. The intellectual bush continue in that direction. So when the politics stream aligns with the problem and the policy stream, then you open the policy window. This is the time. This time here, for us we timed the age limit because he had told us, doctors, you do something about age. We gave an opinion which was not an opinion because we wanted just what? Things to change. This is the time for anybody in Uganda to get any policy action taking place. And as a society, press on. We do a lot of that. I think I have concluded, really, what I wanted to say. Not much, really. This is how imagine this was a typical fridge of blood in Kawempe. Kawempe women's. This is how it was. But now there is excess. If there is no blood in your nearest health facility, it's because the leadership is not doing the what? The logistics. But we fought, and I really want to praise the NRM government. We also had to defend our own. You know, they would just come pick a doctor. Imagine you in theater. There was a time in Mbale, a doctor was operating. And the HMU is waiting outside and sent a report. That health monitor here is waiting for you to finish that mother, then we take you to jail. Can you imagine how are you going to work? The moment she got opportunity, she just went to South Africa. By the time they realized their mistake, she just migrated to South Africa, where she was received with dollars and rands. This is now the side effect. So really, I don't have much to say, but to conclude with a few things. One, I don't need to say everything that I wanted to say. This is what I also learned. But I really want to once again encourage you to continue with the spirit. You have really radicalized. You have faced challenges. You know, facing people who have power is not easy. But I want to let you know one thing. You know, let me see if I have that picture here. You know, decisions are made there. Decisions are made there. For us, what we did, you know, we used to have all these conferences for CLE. We realized we were not moving. Then we started having that, but we don't eat it alone. We say, Mzee, can you come and eat this meat with us here? And it is there that you introduce points. Do not dissociate yourself from where decisions are made and give political leverage. Of course, some of the executive members are now with him. You know, like Okia there is his personal doctor, Oledo is always with him, and that helps. Because these guys didn't come to power in a straight way. They are not going to live in a straight way. So once you realize those facts, you work within your means to improve. Actually, I always encourage my fellow doctors from the West that you go and run in NRM. Win, then come and rekebisha the place. Don't start being a noob there in Ntungamu. They will introduce beating for nothing. You just enter NRM and do it. Thank you very much. I don't have much to say. I had a very short time to say what I wanted to say, but I hope I've made my point. Support the Anthonys. I'm very impressed to see the Vice President being able to take charge. I'm very disappointed that judges could sentence their president. It's confusion. That was even the other time the Chief Justice chasing Semakade not to talk. Total confusion from the Chief Justice. He doesn't know what he wants. Tomorrow, it is the Semakade is protecting those guys. They don't know. Right now, they don't see it. But I'm telling you, when the system collapses, even those benefits will mean nothing. You remember COVID? People were coming to Mulago pleading with the bags of money. There was no oxygen, there was no bed. People were dying there. And I'm very sure our colleagues in the banking sector, they used to have this mega insurance. They have no concern about what the peasant is getting. That Mulago viewers is useless. You tell me which hospital was able to contain COVID. Even in New York, where they are supposed to fly. In fact, that was the source. You are seeing what I'm saying? Let us be concerned about the villager getting justice. In fact, among my proposals, I didn't finish this, is you need to task shift. For us, we task shifted long ago. This business of a doctor doing everything ended. We transfer to nurses as well. How can you be judging everything? You have a mound of cases like this. You are judging from chicken to murder. For us, we have convinced the president that a doctor needs to be at the health center 3. Do you know why? Because we discovered the parish development model is the one having money. We fixed ourselves in the parish development model, said, okay, you go to health center 3. Why? We are training 1,000 doctors a year. Where are they going to work? The excess money is being eaten. So let's fix it. Why don't you have lawyers at the sub-county? You all want to be in the suits here with the fresh air. Go there and work. Those are jobs. That is justice. Justice can be dispensed functionally, but also structurally. Take it down. You know, finally, you know morphine, the drug called morphine? People are dying of cancer. Only a doctor could prescribe morphine. Nowadays, nurses are prescribing more. So you don't have to travel from Barara or Ntungamo or Arua to receive morphine in Kampala. Oh, now morphine, we even manufacture. Actually, Uganda is a model. Because as doctors, we said we are going to task shift. Critical services can be offered down. Lawyers, I encourage you, 1, in summary, take charge of your affairs. 2, remain solid. Munabi, you come and we talk in the evening here, I tell you. And others, Munabi and others. 3, take these services lower to the people. Sincerely, by the way, there is no justice in this country as far as I'm concerned. It's not there, it is to be bought. Thank you very much. I wish you a good evening. And I hope when you invite me next time, I'll be an MP with some of you. Thank you.
Wow. Thank you so much, Doctor. Very wonderful insights. Members, the music has begun playing. Ivan, please come. Let me invite Ivan very quickly. We have had with us Mr. Godbert Mushave since we began this event. Ivan has a simple task that won't take us more than...
I think I will squeeze it in 30 minutes.
Not more than 20 minutes. Please just accommodate us, and we are going to all go and celebrate at the gardens. The drinks won't be served until we get there, so don't worry. They are not serving anything until we get there. So, Ivan, take it away.
Thank you so much. My name is Boe Ivan, and I love having fun. Therefore, I am going to be very fast. Allow me introduce my panel. Mr. Godbert Mushave, Associate Director, the Great Lakes Institute for Strategic Studies, is also spearheading and leading a very powerful savings group called Fortune 500, of which I am a member, and very many lawyers here are members, I know, as a matter of fact. Mr. Godbert needs no introduction. His record from for years speaks for itself, and many of us have had an opportunity to pass through his hands. Many, many lawyers. I'll also introduce Miss Hope. Hope Bagota is a human rights lawyer and works with Uganda Human Rights Commission. I will also introduce Mr. Sempala. All these people have heavy profiles, but if I chose to go into the depth of their profiles, it will take me about 20 minutes. And that's why I'm just introducing what I think is necessary. Mr. Sempala is an advocate for social justice. His other name is Robert. Not Kasvante, not Chagulanyi, but Sempala Robert. And is the executive director of Human Rights Network for Journalists in Uganda. And he is also board chair for the National Coalition for Human Rights Defenders in Uganda. I'll start with the person who has been up there on the podium for a long time, Mr. Godba. With your experience in civil society organizations, are we making strides in making sure that the population is civically alert, but also aware of the human rights? Are you accountable to the citizens as the civil society?
Thanks very much, Ivan and colleagues. Good evening, everybody. Let me find a way of answering Ivan's questions. But actually, to start off from what I had from here, I think I was seated here on the panel. I realized I was the only odd man out because everybody was fearing the scene of crime. I think I would have wanted to be on the scene of crime. Wow. Yeah. Yeah, because members talked about, I think Oriem talked about putting pockets in the hand, yeah? Putting hands in the pocket. Then we called this scene of crime. I think my brother Semuyaba talked about the drama in the courtroom. And for me, that reflected the crisis that we face as a country. Because ordinarily, to have a judiciary block a meeting of a statutory body, for me, I find that quite outstanding. And you see, we are talking about it like, oh, this is a scene of crime because someone has stopped the meeting. Ordinarily, you would expect that the judiciary would enable members of the law society to meet, because there are always remedies to whoever is aggrieved in form of review. So to say that you cannot meet and that's a remedy, then as members of the law society, we are like helpless. I actually said that as a population, we are helpless and hopeless. Wow. Because all the discussions we've had here basically point to that. Number two is the lawyers. My doctor there, Obuku, talked about, you wanted to be a lawyer. I wanted to be a doctor. That was my passion. So by second term of S3, I had mastered all your books, Obuku. Introduction to Biology by D.G. McKean. Introduction to Chemistry by Lambert. Yeah. Modern Chemistry by Atkinson. Physics. So essentially, I was like, I am going to be a doctor. I had the misfortune of going to a school that was starting, and therefore we did not have lab facilities, so we were told we couldn't do sciences. I chose to be a lawyer. And mainly, the reason I chose to be a lawyer was that I should solve problems. My reading today, by the way, in second year of law school, I decided I was not going to go to be a practicing lawyer. I said, I'm going to do something different. And I always make a joke that since I finished law school in 1993, the only time I have been in court, I have appeared there as a witness. And so I sit back and observe the law and the lawyers, and then I realize that we have a crisis. So let me say that in this world, because I've been in civil society, I'm in business, I've spent most of my time working on public policy. So in this world, there are two professions that cannot thrive absent rule of law. The moment you have no rule of law, there are two professions that cannot thrive, and that is the legal profession and the accounting profession. Because these two professions thrive on thriving business. Rule of law enables business to take place, enables anybody who is able to innovate to be able to do business, and therefore business expands. And then as lawyers, we negotiate deals, we draft contracts, we advise on business. So we are at a point where we have a reversal in the rule of law. We have a degeneration in the rule of law. And in most cases, Ivan, we talk about whether the citizens are actually civic conscious. It is also possible to be asking, are lawyers actually civic conscious? Because it's very easy for us to go and talk about lawyers being, citizens being civic aware. But are lawyers civic aware? So I'll just make 3 quick points and stop there. One is that the challenge that you have, the challenge that we have, this law society you are seeing, a book is praising us. I actually think that the law society is as much of a victim as any other institution in this country. So, in other words, all these institutions of citizenship, whether they are professional organizations, whether they are economic associations, whether they are cultural institutions, they have all been weakened and they are all struggling. So the fact that the Law Society cannot hold its General Assembly is not something that can be taken lightly. You know, when we talk about it, sometimes it is very easy to laugh it off. Huh? It looks like funny. But you listen to Anthony, you ask and say, okay, what is the difference between the vice president of the Law Society and some LC3 chairman somewhere in Aleptongo, Ntungam? What is the difference? I lived in Kenya during the dying years of the Moi dictatorship. The Secretary General of the Law Society of Kenya was a gentleman called Paul Mwite. If Paul Mwite was addressing the press in Nairobi about the constitution and rule of law issues, the whole of Nairobi would come down. Because lawyers are lawyers. And I think a book, you understand it, but I don't think that the lawyers of us here, I think that we are too ordinary, that nobody really, I don't think that people have to take notice. Secondly, the lawyers, we have a duty to the citizens. And I think one of the challenges that we've had is that we've, I think there has been a lot of fight with Chiwanuka Chiriowa, the Attorney General. I think that the challenge we have is the Ministry of Justice and the Attorney General, they are supposed to defend citizens. In fact, they are supposed to defend citizens even against the government. But when you have a minister in the names of Norbert Mao talking about his coalition of his political group, and then the Attorney General, basically the one probably engaged in a fight with the Law Society, then there is a lot that is lost. So we need to be looking at the institutions. So the Law Society, where we are now, I don't think that we are getting any better, unfortunately. Even with the radical new bar, you're basically hitting against a rock because, you are dealing with the power. Those who fight to control a Law Society, they understand the structure of power. These are not about legal things. We can go to the courts and argue these cases. I had my brothers here talking about going to court and presenting petitions. So what if you want to present these petitions in a broken system? So it depends on how you maneuver those cases to be able to go through. So from the voter to the candidate to the institutions that are supposed to protect us, they are all in this mess that has been described here. And then finally, it's really about operating in a system where there is no rule of law? When there is no rule of law, you are dealing with authoritarianism. How does authoritarianism manifest itself? Authoritarianism is very, very interesting. It looks better than dictatorship, because in authoritarian regimes, the institutions of democracy, the electoral commission, the parliament, the courts, they all remain functional. They remain in place, but they are playing a field where they actually entrench executive authority. I think a book you were talking about, your president who knelt before the president. But you have a speaker of parliament who kneels before a president. And then you are talking about separation of powers, talking about rule of law. And by the way, the law society is quiet because it has to be politically correct in the kind of environment that we are in. So if the law society cannot call out the speaker of parliament or the institution of parliament, then everything is accepted as normal. And when these institutions collapse, when they degenerate, the law society cannot be saved of that degeneration. And that degeneration then percolates downward to the voter. So no matter how activist or how civic empowered the voter is, if the institutions of state and government are not able to provide, to give you the justice that you need, then you are unlikely. Your civic awareness is actually irrelevant in a broken system where there is no rule of law. So let me pause there.
Mr. Godby, you seem to have resigned. Is it all done? Is there nothing that can be done?
You see, all that I had here, and I think a book also described it in a more dramatic way, is call it adjusting into the. In other words, you have a problem, you keep on adjusting into that problem. I have argued that, and let me put it this way because of this audience. I've argued that where Uganda is now in terms of governance, in terms of breakdown of institutions of state and citizenship, there cannot be an election that is going to save the situation. Unfortunately, I would want to bet on that. I have prescribed the process, which I tried to actually promote with the religious leaders and the elders forum, that our situation now, the brokenness that we have as a country, can be fixed through national dialogue process, where Ugandans come and sit on the table and agree that we have to go into a different direction, and we can go together. Not this group of like, oh, the NRM say they can solve our problems. Of course they can't. The new people say they can solve our problem. Of course they can't. So these problems we are experiencing, the breakdown in the judiciary, the collapse of these institutions, can only be dealt with through a negotiated future where there is a shared vision and a common purpose among all Ugandans.
Thank you so much, Mr. Godba. To my dear Hope, we had an election cycle, and your report indicates that there were human rights violations. To date, some are still in jails because of the 2021 elections. Going forward into the election cycle of 2026, do we have an accountability from the Uganda Human Rights Commission over the violations of 2021? And how prepared are you to make sure that what happened does not happen again, but also to account to the country?
Thank you, Ivan, for the question. In terms of accountability, allow me to start with our mandate as the Commission, which is the Uganda Human Rights Commission has a mandate to protect and promote human rights, and and as a state, as Uganda, the government or the state has the primary duty to see that these human rights are respected, and the constitution that we've been speaking about has clearly laid down all these provisions that indicate that indeed human rights are a very key and fundamental to have free, fair, and credible elections, or an electoral process in that way, whereby the Constitution has provided for civic participation, the citizenry participation. It has also provided that as state actors, we also all have to see that we do respect human rights in the work that we do. So in implementing this broad mandate of the Uganda Human Rights Commission, during elections, that is the process, the entire process, pre, during, and post process, the Uganda Human Rights Commission has an app that we use, number one, that helps us to document where all these issues are happening. And also I want to thank Mr. Sempala here. We really do also rely on the media reports, because we cannot be across the entire country. We would love to be everywhere, but unfortunately, because of limited finances, we are in few districts and also here at the head office. So through different partners, we get this information. When this is documented, we go ahead and do interventions. We work together with public interest litigation lawyers. We also do go ahead and foster or call for what Dr. Godba has been speaking about, the national dialogues. We've had quite a number of them. And what the message is we are preaching peace. We are saying we need to have free, fair, and fair elections, but peace cannot thrive when we have injustice. Someone cannot sit with you at the table feeling grieved and you're preaching to them peace. So we bring all the common actors on the table, that is state and non-state actors, and do remind them of their duty, which is to protect and promote human rights. So meaning we do work closely with the Electoral Commission, working with the security officials, working with the judiciary, working with civil society, working with media. And all this is geared towards reminding these state actors that they have the key responsibility of respecting and promoting human rights. Are we there yet? Human rights work is always work in progress. We can't sit down and fold our hands. We keep calling for these changes, and collectively, we are of the view that we are going to see some of these changes. So how are we prepared moving forward? As we are all aware, the mandate of civic education is for the Commission. This mandate is a very huge mandate. We do implement it, but we do work together with partners. And Uganda Law Society is also one of those particular partners. And we also call on the different stakeholders to join us, and we execute this mandate. How is civic education done? We go to community barazas, we speak to the general public. But this issue that we've been hearing in the room of touching the pocket, even in the grassroots, it's there. Colleagues, I will not shy away from telling you that if you went to a community and told them we want to sensitize you about elections, the question will be the Luganda word that we usually hear, mfuniramu wa. That's the realities that are with us. When Mr. Godba is talking about issues of degeneration, colleagues, these things are here with us. They're in our society. But we cannot fold our hands. We have to, it's a call to action. Can we start with ourselves? So as Uganda Human Rights Commission, like I had said earlier, when we are speaking and engaging with the different stakeholders, for example, let's say security. Yes, you're mandated to protect law and order. We do agree that there will be issues that will come up. But when they do come up, or when these violations do come up, what action is done? Is it the disciplinary mechanism within and it's left at that? Or do you bring this to the public to know? Because people have to see that justice is being done. It should be seen to be done. And then this will also deter another person from doing the same. If it's Electoral Commission, our call is usually honor the process. If along the process it's registration, are we letting people know we are registering, we are updating, we are changing these particular polling stations, you've been moved to here and there. But also as citizens, remember that our rights come with responsibilities. Are we honoring the responsibilities as citizens? One of the councils in the previous panel asked, if they asked some of us here, if we updated our national IDs, what would our response be? No, we've not updated. So as collectively, together in implementing our different responsibilities, as well as also the state actors who are the key duty bearers, implementing their responsibilities, we can see some change. It has to start with us. It has to start somewhere. One of the colleagues said we should move from lamentations to actions. Ask yourselves, inward reflection, what are we doing? How are we contributing as lawyers to this civics space, to this human rights journey? Are we takers from the journey, or are we putting something in this particular journey? We also go ahead and document. You may say, okay, you're documenting, then what happens? This is a constitutional mandate for the Uganda Human Rights Commission to make periodic and annual reports on the state of human rights across the country. When these reports are made, we don't shelve them away in our offices. We present this report to Parliament, and this report is deliberated on by the Human Rights Committee of Parliament. We are happy to report that now the Human Rights Committee of Parliament has taken keen interest in the issue of prolonged pre-trial detention. Colleagues, it's very sad to go to prisons, because we monitor, we visit these prisons, to find someone has been in prison for 8 years, 10 years, without a day in court. Imagine if you were that person. 8 years, 7. So now, because of our reports, this documentation that we've been doing, Parliament has taken interest in this and tasked the Ministry of Justice to address these particular matters. So this documentation is not in vain. It gets us benefits now, and also for posterity, we have a legal, we are leaving a trail that we can build on to see that we improve, because human rights is all about improvement. And across all the elections, we have been making reports on these elections. And the recent one being the 2021 elections report, which are all available on our websites of the Uganda Human Rights Commission. Thank you very much.
Thank you so much. Mr. Sempal, you are a member of the Fourth Estate. The Fourth Estate, we cannot say enough about its relevancy in civic education and promotion of human rights, or even reporting the violations of those that are supposed to promote human rights. Is the industry and the players, are they independent? Is the industry independent and are the players independent to fulfill this mandate to the citizens?
Thank you very much, Ivan. For the record, I wanted also to be a lawyer. But now I'm associating with lawyers through somebody who is the Minister of Internal Affairs at home. So I get to know a lot about the fraternity. By osmosis. And very soon I'll equally join. But drawing from Dr. Kabumba's assertion there, that 0 times a million is a 0.
Yes.
Just like Godba has said, where all institutions seem to be crumbling, you cannot entirely come out to say that the media is very strong, it's independent, and it's all working well. For those of you that have been here long enough will know that we have a multiplicity of media houses, but that does not directly translate into media freedom. You know that there is very limited access to public media. You know it for a fact. You know very much that the pattern of ownership of media houses in this country renders it depending on individual ownership. And there is a lot of media capture in this country. So you literally will see trickles of the capture in how we report about civil and political rights mainly, where you find the political leadership has come into bed with media ownership to crusade for particular interests, especially bordering on individual businesses. And so where you see a semblance of an independent media is where the owners and the journalists are independently trying their best to come up with what is a semblance of a media, you know, to be able to explore the full mandate of what a pluralistic, independent, and free media would be doing in a society. So where we are at now is very hard to say that our media is independent. I work for a media rights organization, but I also work closely with the National Coalition of Human Rights Defenders. I'm a board chair, and we take the journalists to be human rights defenders. but also take the media to be part of the wider civil society. And you know how many hurdles media or journalists have to jump in order to hold the powerful accountable, in order to expose the gross abuse of power and offices, in order to expose violations of human rights, in order to just put on table an independent report which can be widely used by those that advocate for pluralistic rule of law, democracy, and respect for human rights. I know it for a fact that the lawyers do try a lot, but in the same vein, I know that journalists try as much, to pass off as bringing a just society into play. It's never been easy, but our hopes are not all shattered. To say we do not have an independent media, so all is lost. Because we have journalists that really do very credible work, that have really exposed a lot of rot that happens into public offices, and some have even led to prosecutions, some have led to arrests. And that is why those that have been so duly buried into capturing the media came up with a computer misuse amendment that now made it almost a crime to practice journalism and even citizen journalism. And that was adding on to what we already have as a media capture. So about your specification, we cannot say that the current media is independent, equal to the task, and freely operating.
Thank you so much. I have one, because of the time constraint. Goodbye is ready. I can go first, yeah. So, the elite discussion. I think it's a very relevant discussion, but probably I would say this misdirected. Because you see, most people are blaming the elites and say the elites are responsible for the problems that we are experiencing. I would say that the elites are also victims. We have to understand this problem we are dealing with a structural problem. This is not some process, this is not some anecdotes. You are dealing with a structural problem. So because society is a structure, so you look at the different structures, and society generally is comprised of two segments broadly. You have the state, you have the citizens. So the state, that we know, these are institutions of state. So we know our three arms of government. Those are known. And then there are state institutions of all kinds, whether they are governance institutions, they are economic institutions, they are social institutions and the like. So that's the structure of government. So you have to be looking at what is the structure of government working. So you have the structure of government not working. As I mentioned earlier, you have a system that has been degenerating. Because you see, in 1995, when we adopted the new constitution, that was an attempt to reorder and restructure government. And because the institutions of state were created and were basically meant to operationalize them. I think if there is any blame on the elites, it is the fact that we probably took a back seat as people who understood power, basically restructured the structure of power. So the restructuring of the institutions of state is about restructuring power. So we've had I would say the misfortune actually of having a president who understands the structure of power. So he knows how to structure power, he knows how to harness power, he knows how to use the power to disorganize. In fact, if President Museveni today wanted to use power to move this country in the right direction, he is probably one of the best placed persons to be able to do that. But he knows
how to use the power to be able to achieve his objectives. I think at another event I was basically saying that one of our challenges is that President Museveni has basically transformed his ambition of holding power into a national vision. So now everybody now runs around. So all these NRM people you see running around, voting, stealing elections from each other. They don't know what they are even running about. So they are all confused there. So that's the state. The second segment is the one of citizenship. I alluded to it again that citizens are organized in formations. As individuals, we are very helpless. We only have our citizenship, our sovereignty is only possible when we aggregate it in form of citizens' formations. So those who believe in political parties who are contesting for political power, they organize in political parties. Those are political citizens' formations. Those who are engaged in economic activities, they organize in economic formations. The most apt of this is the cooperatives. But someone who knows the structure of power knows that if you have strong economic formations like cooperatives, they become a problem. So you dismantle them and create circles. Citizens are organized in professional associations. So the lawyers come together, the doctors come together, the engineers come together, all these, the surveyors. And these are strong. A person who wants to hold on to power, I can tell you, even if it was any one of us, you don't want a strong law society. Why would you need it? That's a problem for you. Lawyers. And you let them organize. No, we will create every mechanism for God to be fighting with Samakade, Robert is fighting with Bowe. We will create that and it will work. So, in other words, are we a problem? I think maybe let me end with this point, because if I was looking at elites as a problem, I would say it fits within the overall problem, which I say that the current regime I think has really programmed Ugandans in a very, very bad way, which I call lowering the imagination of people. So in other words, our imagination as elites has been lowered to the lowest common denominator.
Thank you so much, Mr. Godba. My brother, Sempala.
Yeah, if you have, thank you very much, but if you have the minimum standards for one to become a member of parliament as S6 or its equivalent, then where is the place of the elites in the society? Because parliament is one of the epitomes of class for governance in this country. And that really renders the elites vulnerable and all by themselves. And it's no wonder that the elites have resigned to fate as well. But it's not only the elites, but there is generally even voter apathy. People are really resigning a lot to fate in so many dimensions. You go to the police, everyone is looking for how to survive. You go to the army, they don't know who to take orders from. You go to the teachers, they're saying we're sitting down, others are saying let's go and teach. They're polarized between science and arts teachers, all go to the same institutions, teaching in a common school, but you're saying, no, you are divided. So this practice for me is orchestrated by the leadership of this country. Like Godba said, if there's anyone that can organize better, it's the president of this country. During COVID times, all of you saw, Seven would say, all of you should be home by 2 p.m. We'd all go running and sweating and would be in our houses. He says, no churches, no church opened. He would say, no market dwellers. There was nobody in the market. Until he said, people going to farms can go and, do your farming. And people started moving a bit. You find business people moving in those trucks like farmers. So I think it is a matter of, focusing on this, and the elites will be back to, to practice. They will be in the right spaces. As of now, it's very hard to pull the elites into, that critical mass that you need to see and foster the country.
Thank you so much. My sister Hope.
Mine would be that as elites, everyone in their collective capacity, let's play our role. Why? Because the politics of the day end up affecting us. We might not play politics, but we are going to be victims of politics. So let's do something about it, not to just sit back and be in the book of lamentations like our colleagues have been earlier on alluding to. Thank you very much.
Thank you so much. I will not go any further because we have a party outside. Thank you so much for listening, and thank you the panelists for such a detailed discussion. Thank you.
One last thing as we go. I was trying to run to make it on time. Members, I want to just have Mr. Babu come and tell us where our drinks are, and then deliver a vote of thanks as well.
Good evening, colleagues. On behalf of the Uganda Law Society, I wish to deliver a vote of thanks to all the members of the bar who have endeavored to come through and attend the training of today, even when the same was communicated on short notice and amidst the ongoing concern of a potential contempt. And I also, in a special way, wish to thank our speakers for accepting our invitation and also being bold enough to come at a scene of crime at such a critical moment. I have been advised by the governor that the drinks are down there. That is what I've had, down there. So let's go down there and enjoy the president's cocktail. Thank you.